Welcome, 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 welcome. Thank you, thank you, thank you. Good afternoon and welcome to the Judiciary Committee. My name is Senator Justin Wayne, and I represent Legislative District 13, which is North Omaha and Northeast Douglas County, and I serve as the Chair of Judiciary. We will start off today by having committee members and staff do self-introduction, starting with my right, Senator McKinney.
Good afternoon, Senator Terrell McKinney, District 11, North Omaha.
I'm Wendy DeBoer. I represent District 10 in Northwest Omaha.
Good afternoon, Senator Carol Blood, representing District 3, which is Western Bellevue and Eastern Papillion, Nebraska.
Rick Holcroft, District 36, West and South Sarpy County.
Good afternoon, Barry DeKay, representing District 40. Those counties include Holt, Knox, Cedar, Antelope, northern part of Pierce, and most of Dixon County.
Also assisting us is our committee pages, Laura Burtek from Norfolk, who is a political science major and criminology major at UNL, and Isabel Cole from Omaha, who is a political science and pre-law major. This afternoon, we'll be hearing 7 bills on a Friday, and we will be taking them up in the order listed outside of the room. On the tables in the side of the room, up here, or right up here to the right of me, your left, are blue testifier sheets. If you are planning to testify today, please fill out a blue one and hand it to the page so we can make sure we keep accurate records. If you don't wish to testify and want to record your presence, please fill out a gold sheet and we will record your presence for the record. Also, I'll note that it's the legislature's policy that all letters of record must be received by the committee noon the day prior to the hearing. If you have handouts, please have 10 of them. If you don't, please give them to our pages ahead of time before you come up so we can get 10 copies for the committee. Testimony for each bill will begin with the introducer statements, followed by opening statements. You will hear from supporters of the bill and those in opposition of the bill, followed by those speaking in neutral capacity. The introducer of the bill will be given the opportunity to make closing statements. Because it's Friday, today is no question Friday, so you won't get any questions from the committee member. I'm kidding. We'll ask you plenty of questions. Before you testify, please state your first and last name and spell them for the record. We will be using the 3-minute light system. When you begin, the light will be green. At the yellow will be 1 minute warning. Red, we ask you to wrap up your final thoughts. And I'd like to remind everyone, including senators, to please turn off or silence your cell phones. And with that, we will start with Senator DeBoer, LB 799. Welcome.
Thank you, Senator Wayne. Members of the Judiciary Committee, I'm Senator Wendy DeBoer, WENDY-DEBOER. I represent the 10th Legislative District in Northwest Omaha. I'm here today to introduce LB 799. LB 799 is a bill that reflects a piece of the biennial budgeting process addressing state salaries for the court system's judges. As currently structured, all Nebraska judges are paid using a statutory formula based on the salary of the Chief Justice. LB 799 then proposes an increase to the chief's salary that will result in a commensurate increase in the salaries for the justices of the Court of Appeals, district court judges, county court judges, and judges of the separate juvenile courts. I am passing around, or you already have, AM 761, which is an amendment that adjusts the salary to reflect a 7% increase for Nebraska's judges in year 1 of the biennium and a 6% increase in year 2. The amendment reflects a negotiated agreement between the judges and the administration with respect to the budgeting process. And I understand that this committee says that the shorter the testimony that follows me, the more likely that is to happen.
Yes.
There are a number of testifiers behind me who intend to provide you some additional information in Nebraska's judges' salary structure, the need to offer salaries that ensure that we have qualified candidates applying for judgeships in Nebraska, and the history of judicial salaries in Nebraska. Considering where this bill fits in the context of the budget process, I'm hopeful that the committee will consider this bill and advance it from committee soon. Thank you, and I'm happy to answer any questions that you might have.
Any questions from the committee? Seeing none, thank you, Senator. For real? Senator McKinney.
Are these increases coming from the general fund or cash reserves or anything?
General.
General fund.
Okay, thank you.
I was supposed to introduce this bill, but I was in court that day. Judges got a little worried, gave it to DeBoer. All right, first proponent, Chief Justice Heavick. Welcome.
Thank you very much. My name is Mike Heavican, that's M-I-K-E, and Heavican is H-E-A-V-I-C-A-N, and I am the Chief Justice of the Nebraska Supreme Court. Senator Wayne, members of the Judiciary Committee, thank you again for your attention to today's judicial bills, especially the Judge's Salary Bill, LB 799. LB 799 currently schedules, as noted, a 7% raise for judges in fiscal year 23-24, and another 6% raise for judges in fiscal year 24-25. And as also noted, the governor's office has agreed to these increases. LB 799 changes section 24-201.01 of the revised statutes, which triggers salary increases for all Nebraska judges, including the Court of Appeals, District Court, County Court, and so forth. This request is based on the need to attract and retain good lawyers for Nebraska's judiciary. We need to have judicial salaries remain competitive, not only in comparison to the salaries of other public employees, but also in comparison to private practice incomes, so that we can attract diverse and qualified individuals to serve on Nebraska's bench. Candidates for judicial office must typically make career and life-changing decisions at a critical point in their professional lives. If a lawyer chooses to become a judge and is so appointed, he or she, for all practical purposes, forgoes the opportunity to build a lucrative private practice or to resume a leadership career track in another public sector position. Our judges solve legal problems and disputes, both large and small, and do so with patience and grace. Every case is important to someone, and every case is important to our judges. There is no better investment you can make in the future of state government than investing in competitive salaries for the judiciary. Our judiciary will likely be in place long after most of us in this room have left public life, and is key to many critical issues facing Nebraska and Nebraskans. On at least 4 occasions in the last decade, not enough qualified lawyers, that means a minimum of 2, applied for an open judgeship for the governor to make an appointment for a judicial vacancy. While several factors have contributed to this previously unheard of occurrence, the need for competitive salaries is definitely one of those factors. I recommend the passage of LB 799, and I would be happy to answer any questions.
Any questions from the committee? Senator McKinney, followed by Senator Geiger.
Thank you, Senator Wayne, and thank you, Chief Justice. What do you think is the judiciary's role in our fight to address the issues within our criminal justice system?
Well, obviously, judges do all of the individual cases. They have to hear all of the criminal cases that come in front of them. Every one of them is in front of a judge. So judges obviously have a big part of that. Now, you probably are talking about broader kinds of issues. We have an access to justice committee that works on all kinds of issues to better serve the people of Nebraska, and we have a number of issues in regard to things like that. We have a robust education system for our judges and other employees in the judicial branch. So we try to help our judges understand and think about things like diversity and that sort of thing. So I think obviously we're important in each individual case and have a role as part of government to do our best job we can for all Nebraskans.
Okay, 'cause, well, we served on the task force looking at the criminal justice system a year or two ago. And one of the things that came out was the discretionary use of consecutive sentences by judges. And because of that, we have really a logjam in our state prisons because the length of stays have increased. Is there a reason for that?
Well, judges sentence really in the sentencing range that this body gives. So each of those cases individually, judge has to decide. And if they have the option to sentence consecutively or concurrently, and sometimes they don't have the option, but if they do, that is up to an individual judge in an individual kind of case.
Yeah, no, I understand that. It's just in the numbers that were shown to us, it was told to us in the report that a lot of the increase in consecutive sentence was discretionary and the judges were doing it. It wasn't just because it was statutorily required. And I just wanted to ask that because one of the biggest issues with getting changes in the system is that we have so many people consecutively sentenced or over sentenced or sentenced for long-term sentences. And although admissions are decreasing, we just have so many people in the system. And I just was curious about that. And then my last thing is, how do we increase diversity in judges in the state of Nebraska?
That really is a long-range kind of thing. I think you have the Nebraska Bar Association in cooperation with the two law colleges in the state. And we are, as I said, we have an Access to Justice Commission. We work on those kinds of issues. At the Supreme Court, for example, we go out to high schools and we hope that when we do that students will see a little bit of what the judiciary is about and what the law is about. And we hope to attract young people to become lawyers so that they can, one of their options then is to become judges. Ultimately, the system in Nebraska for selection of judges gives a lot of power to the governor. It gives power to local bar associations. The legislature has no specific role in the appointment of individual judges. It all goes through the committees and so forth. And for example, I can't call up and lobby for a particular judge. That's forbidden by statutes. But I can encourage and have encouraged, for example, lawyers of diverse groups to apply. And that's really our role in the more immediate kind of situation. In the long run, this is something we have to attract young people to become lawyers, young people with a diverse background to become lawyers and get involved in the system. We try to do a lot of that.
Thank you.
Yeah.
Senator Geiger.
I'm curious how we're doing state to state on salaries for our judiciary.
Right.
Are we competitive in our surrounding area?
We are competitive, and I would thank this body and the recent governors. You have been good to us, and we are competitive with our neighbors. As at this moment, as you know, this is legislative season. Every state's judges, every state is going through the same process we are. And I can guarantee you they are all asking for very large raises for a lot of reasons. One being there's been a lot of inflation in the last year or so, and most states have a little more money than they normally would. So we are in a very good place competitively right now, but we want to make sure we maintain that position.
Good, thank you.
Thank you.
Any other questions from the committee? Seeing none, thank you for being here, Your Honor.
Thank you.
Next proponent. The other reason why I didn't take this bill is the governor's office has never tested positive when so I'm going to keep the tradition going.
Making history.
Welcome, sir.
Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Dave Lopez, D-A-V-E-L-O-P-E-Z. I have the privilege to serve as Chief of Staff for Governor Jim Pillen and Lieutenant Governor Joe Kelly. I'm here to testify on behalf of the governor in support of LB 799 as amended, with the amendment described by Senator DeBoer, which reflects an increase in judicial salaries by 7% in the first year of the biennium and 6% in the second year. I'm particularly pleased to testify in support of this amendment because it is the product of a very positive agreement between Senator DeBoer and the executive and judicial branches, hopefully soon to include the full legislature. Maintaining competitive compensation for judges is, as the Chief Justice described, critical to ensure not only that Nebraska benefits from as broad a pool of applicants for judicial vacancies as possible, but also to ensure that we benefit from the experience of veteran judges throughout their careers. That experience is necessarily a product of longevity on the bench, which is incentivized by competitive pay. The governor well understands the importance of the judiciary and the challenging work our judges undertake every day, and I can tell you his team does as well. He is therefore pleased to support this compromise amendment, which will maintain Nebraska's status in the upper tier of judicial compensation relative to our fellow states. Thank you, and I'm happy to answer any questions.
Any questions from the committee? Seeing none, thank you for being here, sir.
Have a great weekend.
Next proponent. Welcome, sir.
Thank you, Chairman Wayne, members of the Judiciary Committee. I am Corey Steele, C-O-R-E-Y-S-T-E-E-L, and I'm the Nebraska State Court Administrator. What is getting handed out to you is some data to back the need for judicial salaries. My office obviously is in full support of the amendment, and thank you to Senator DeBoer and others and the governor's office for working with us over the past few weeks to months on this compensation package. A few things I want to highlight in the information that's been given to you. This is a 10-year look back at judicial applicants for the state of Nebraska and the number of applicants that have come into the office for different positions based on the years, both public attorneys and then also private attorneys that then have become judges as we continue to see the decline in the amount of public judges private attorneys that become judges. That's an issue for the bench. One of the things we talk about is the health of a good judiciary is a robust, diverse group of judges that come from all practices of the law. So we have civil attorneys, we have attorneys that do probate work, that do divorce work. We also do the domestic docket. We have judges that come from the county attorney's office and do criminal. And we also like to see attorneys that come in that from the public defender or defense counsel. That makes a robust judiciary. So we don't have one group of judges that have practiced in one area throughout their time. The next page shows you the average number of applicants. We have seen a dramatic decrease in the number of applicants for an open judgeship. As you can see, we were averaging 7 to 8 up to 10 judges or individuals that applied for those open judgeships. We were down to 4.5 on average in 2022, and the first judgeship in 2023 had 3 applicants here in Lancaster County, Nebraska. The last thing I want to wrap up with is average pay for attorneys that are partners in law firms, which judges that have been attorneys for a long time would be a partner in that point in time. They're averaging just below $260,000 a year, which is significantly less than what our judiciary makes, between $50,000 and $70,000 less a year than a judge would make. So again, it's important to have a diverse bench. It's important to pay our judges what they would come close to, not saying we have to match, but close to in the private sector. Otherwise, we will see a continued decline if you can make more money by being a private attorney out in the community than applying for these judgeships. I'll wrap up there and answer any questions that anybody may have.
Thank you for your testimony, Senator DeKay.
Thank you, Senator Guys. Thank you, Mr. Steele, for being here. You said there's a decline in applicants for judges coming forward. With that note, the 2 law schools in the state of Nebraska, the number of lawyers coming out of law schools, are they declining, staying same, or going up?
I think we're starting to see that curve come back and an increase of individuals back in the law school after the last few years. There's a lot of recruitment efforts with the law schools, not only to recruit people to come to Nebraska, the University of Nebraska-Lincoln and Creighton, but also within our state. Our law schools, the University of Nebraska-Lincoln has partnered with 3 other colleges here in Nebraska, University of Nebraska-Kearney, Wayne State, and Chadron State. And they have a program where they call the Legal Opportunities Program. And they give scholarships to individuals that come to those 3 schools with the incentive to go into law school at University of Nebraska-Lincoln. And so there's a lot of things to assist to try and increase the pool of applicants to the law schools.
One more question, if
Sure.
I can. How long does a lawyer typically practice before if they do have aspirations to be a judge? How long, is there a criteria they have to meet before they can apply?
There is, and it's in state statute. There's a requirement of age and number of years that you've practiced to be a lawyer, or have practiced to be a lawyer than to apply for a judgeship. And off the top of my head, I believe it's 5 years. Well, here's what I'll do. I'll defer Judge Strong, or Judge Freeman is going to testify after me, and they went through this process, so they'll probably know exactly what that's, so I don't mess that up without looking at that ahead of time. Otherwise, I can get back to you on that exactly.
Thank you.
But it is statutory.
Any other questions? Yes, Senator McKinney.
Thank you, Senator Guys. Thank you, Corey Steele. I'm curious, what's the demographic breakdown of applicants, of those denied, approved to be judges, those that were PDs or county attorneys? Because I've talked to some lawyers, and a lot of them are hesitant to apply or don't apply because it feels as though if you're not a county attorney, you don't become a judge. So how do we change that? And is there a way that we can get the information of the applicants, what were the race, what were their age, did they get denied, or did they get approved?
Great question. And because of this study and the data that I've given you up to this point, those are data points that we don't collect at the time of judicial application, such as race is not collected at that time. We have public or private attorney, right? If they come from the public sector or the private. Again, it could be a county attorney or a public defender, or the attorney general's office or something like that if it's from the public sector. But that is one thing that we've really taken a look at based on doing this study, is we're not gathering enough information at the time of application so that I can produce those types of reports that say, what's the average age, of the applicant, what is the race and demographics of the applicant, what practice are they in? And so those are things I think that we're going to work towards so we can start collecting that data.
All right, thank you.
Yes,
Any other questions from the committee? I do not see any. Thank you for your testimony.
thank you.
Any other proponents? Good afternoon.
Good afternoon. Thank you for allowing me to speak today. I'm Susan Strong, S-T-R-O-N-G. I'm one of the 8 district court judges that we have here in Lancaster County. But today I'm speaking on behalf of the District Court Judges Association. And first I want to thank Senator DeBoer for introducing this bill, and also thank Governor Pillen for agreeing to the amendment. I wanted to talk about the importance of maintaining a judicial branch and how we go about doing that. Of course, as you heard, one of the essential ways is to get a qualified pool of candidates to apply for these judicial positions. Just recently, as someone mentioned, we had a district court judge position open up in Lancaster County as a result of the retirement of Judge Ott. Only 3 lawyers applied for that position. And when I talked to other judges across the state this week, I learned that that is a similar circumstance that is occurring over and over again. In fact, I have been told that only 3 people applied for recent vacancies in Douglas, Hall, and Saline County. And quite often, all the candidates that apply are already in government service. The 3 people who applied for Judge Ott's position were either state or county employees. So we believe the dwindling number of judicial applicants is directly correlating to our salary issues. The number of candidates from the private law practice are few and far between these days. In trying to convince lawyers to apply, I've been told that it's too big of a pay cut for too much work. And I've heard that not only from lawyers in Lincoln and Omaha, but from lawyers across the state. District court judges handle criminal, civil, and domestic cases. Our criminal docket is crucial to the safety and welfare of your constituents. But even if you think the general public will never come in contact with these criminal cases or be involved in them, as we hope they're not, at some time in their lives, they may have to rely on the judiciary to resolve civil and domestic disputes. Trial court judges make decisions that impact people's daily lives. For instance, we decide if someone is wrongfully terminated from their employment, if someone is allowed to recover for injuries suffered during an automobile accident, or whether somebody gets custody of their kids, and whether they receive child support to help them to take care of those children. So we need a competent and independent judiciary to assure that the constituents are well served. Our salary increases have not been keeping up with the cost of living increases. I received data from several judges complaining that while the consumer price index has risen by 8.5% to 9% over the last couple of years, our judges' salaries have increased by only around 3%. Judges are really feeling the lower salaries, especially during these last few years of inflation. So we need qualified candidates so that we can have qualified judges appointed.
I hate to stop you, but I have to continue the tradition of the committee. Are there any questions on the committee? Senator
Would you
DeKay.
want to wrap up your statement real quick? Finish your
Oh, sure. I was just going to say that to get those qualified applicants, we have to be competitive in salary across the legal community. So we want to attract applicants from the plaintiff's bar, the defense bar, and corporate practice. And we believe we're stronger when we are more diverse in background and experience. And I'll take any questions.
Any questions? I actually have one.
Sure.
I'm going to guess that this is a quite stressful job.
Yes.
And I wonder if that also paired with the salary might be a reason that you only get a few applicants. I guess maybe that's common sense, but I don't know that people fully appreciate, and I'm sure I don't. I only know in part from some of the judges with whom I have a good relationship. But you serve a very vital function and a very difficult job.
It is a difficult job, but it has been for the last 50 years. And just recently is when we're experiencing this lack of people wanting to apply. So that's really concerning for us.
And you think that is solely the pay differential between private and public?
I can't say that that's the sole issue, but we believe it's close. I mean, we believe it's tied to that issue.
Okay.
And when I told the other judges that I was going to be speaking today, on an influx of emails, I became the most popular judge in the state instantly. When you tell somebody you're going to talk about whether or not they're going to get a raise.
Yeah.
But and I was surprised, frankly, by how many from all across the state were giving me the same concerns that we have here in Lincoln and Omaha, that the lack of applicants, the salary not keeping up with the cost of living, and even judges in our smaller communities are feeling that pinch. So
Well, thank you. Thank you for what you do, and thank you for your testimony. Senator McKinney, do you have a question?
Thank you. How do you build confidence in those that are not county attorneys or working for the attorney general to apply because they feel as though it's a waste of time?
Well, we have had several people from the private sector in the past who have been judges. I think the best thing that we can do as sitting judges is to try to recruit. And we do that. We've just been having a more and more difficult time in doing that these past maybe 5 years. But you're right, we need more diversity, and that's what we are after. We want people to apply from all over.
Because I think we need judges, we need our judicial system. I just think that we have to get better at diversifying the bench.
Right.
So all perspectives are on the bench and represented. And that's all I was thinking about. Thank you.
Unfortunately, sometimes it is a political process. So you have that in
It's a
play
problem
too.
too.
Yeah,
It should be.
but there's nothing I can do.
All right, thank you.
Any other questions? I don't see any. Thank you for your testimony.
Okay.
And your service. We appreciate
And
it.
by the way, you have to be practicing for 5 years and 30 years old to apply for a judgeship.
Thank
So,
you.
Just a quick.
Good afternoon.
Good afternoon. My name is Trisha Freeman, TRICIA-FREEMAN. I am a county court judge in the 2nd Judicial District, which consists of Sarpy, Cass, and Otoe counties. I am one of 4. I appear today on behalf of the County Judges Association in support of LB 799 and its amendment. I thank you, Senator Wayne, and members of the committee for giving me an opportunity to testify today. And I'd like to take the opportunity to thank Senator DeBoer for bringing this bill. Chief Justice Heavican began his State of the Judiciary address in 2021 by reciting Article 1, Section 13 of the Nebraska Constitution, which states that all courts shall be open and every person for any injury done to him or her shall have a remedy in due course of law and justice administered without denial or delay. And you can tell from the text, there's no exception, not even a national pandemic. Members of our communities across Nebraska rely on the courts to be available, to hear their disputes, and to resolve them fairly, competently, and timely. To do that, we must maintain adequate judicial salaries to attract and retain good qualified lawyers to fill judicial vacancies. County judges across Nebraska have exclusive jurisdiction to hear matters involving our most vulnerable populations by appointing guardians and conservators and decreeing adoptions. We also settle issues in estate proceedings, address landlord-tenant issues, and decide a large variety of small claims and civil disputes. County judges touch most criminal proceedings filed by setting bonds and conducting preliminary hearings in felony cases and managing all aspects of traffic and misdemeanor cases, not to mention the countless search warrants and arrest warrants we issued at any time of the day or night. In most counties, county judges share responsibility with the district courts for handling protection orders. And outside Douglas, Sarpy, and Lancaster counties, county judges also have juvenile court jurisdiction. As you can see, the judicial branch must continue to attract a diverse group of applicants from all practice areas to fill current and future vacancies. I can say personally, I'm grateful for my colleagues whose practice area was different from mine and who are willing to share their knowledge and experience on matters awaiting my decision. Outside of their courtrooms, many county judges participate on committees to improve our courts, service to the public, and access to justice, as well as to serve their state and local bar associations to improve law practice and administration of justice. The role of the judicial branch is integral to strong, healthy Nebraska communities. I thank this committee and the legislature for historically understanding and supporting the need for competitive judicial salaries, and ask that you advance LB 799 as amended to general file. And I'd be happy to answer any questions.
Any questions from the committee? Senator Holcroft.
Thank you, Chairman Lane. Just a comment. I recently spent some time in your court as an observer.
There's a majority.
I wasn't judging.
I just wanted to say, I thought you ran your court very professionally. Well done. Thank you.
Thank you.
Any other questions? Seeing none, thank you for being here.
Thank you.
Any other proponents?
Thank you, Chairman Wayne. Members of the committee, I'm Jason Grams. I am JASON-GRAMS. I'm the president of the Nebraska State Bar Association, here to testify in strong support of LB 799. Currently, the justices of the Nebraska Supreme Court are paid $192,647.09 per year in salary. Lower court judges are paid a percentage of that salary, ranging from 90% for county court judges to 95% for Court of Appeals judges. The NSBA periodically conducts a salary survey of attorneys in private practice. Attorneys completed the most recent survey in 2022, and although we have not published the results yet, we have some preliminary numbers we'd like to share with the members of this committee. 145 Nebraska attorneys who described themselves as a partner or owner of a law practice responded to our survey last year. According to the survey, the mean salary of a law firm partner in Nebraska is $258,283 per year. That means Nebraska Supreme Court justices are currently paid under 75% of what they would make as an average law firm partner, and lower court judges up to 10% less than that. And it should go without saying that Nebraska does not need below average judges. For many years, Nebraska's been blessed with an excellent bench. It is essential to the operation of this state that this continue. However, some recent disturbing trends are reducing the number of candidates who apply for judgeships. The NSBA is frequently called upon to help fill candidate pools when not enough candidates apply for judgeships. This has been happening more and more frequently, as you've heard in prior testimony, and it is not limited to the rural parts of the state. For example, the most recent search for a district judge in Lancaster County yielded only 3 applicants in a county of approximately 325,000 people and 1,260 licensed lawyers. Low salaries relative to the private sector is not the only factor causing the lower rate of applications, but it is not helping. We need to correct this trend before it impacts the quality of our judiciary. That means judicial salaries must keep up with inflation and be at least somewhat competitive with what these public servants would earn as private attorneys. I understand there's been an amendment. The NSBA supports this bill as amended. And on behalf of the legal profession, we thank the committee members for your attention and encourage you to advance LB 799. Are there any questions?
Any questions from the committee?
Thank you.
Any other proponents? Proponents? Seeing none, turning to opponents. Any opponents? Anybody testifying in neutral capacity? Neutral capacity. Seeing none, as Senator DeBoer comes up to close, we have one letter for the record. That letter is one letter of support.
Thank you, Senator Wayne, and I want to thank all the folks who came to testify today for the hearing. I think it's so important for us to think about judges' salaries and all the work that they do, especially as we're thinking as a body, as we as a committee are giving them more and more work to do when we ask them to do more and more with problem-solving courts, which are very intensive obligations. So I think it's very important to think about making sure that they have the salaries to keep them competitive, because as Senator Geis pointed out, it is a stressful job, particularly as we give them more obligations. So I think that we should very strongly, I want to very strenuously ask this committee to advance LB 799 to increase their salaries, as we're thinking about salaries throughout the 3 branches of government, to increase those so that we can get the best candidates, not just for judgeships, but as we're going through this session to think about our own staff in the legislative branch and increasing their salaries and all the other folks that we can. So we as a full government can be doing the best for our people and getting the best people for the job. So I'll answer any questions you have.
Any questions from the committee? Seeing none, thank you for being here. And that'll close the hearing on LB 799, and we will open the hearing on LB 494. Senator Dungan. Welcome to your Judiciary Committee.
Good afternoon, Chair Wayne and members of the committee. I apologize for being just a couple moments late. My name is George Dungan, Georgedungan. I'm the state senator for District 26, representing the people of Northeast Lincoln. Today, I'm introducing LB 494, which makes a minor but important change to the Nebraska Rules of Evidence in order to align them with the federal rules of evidence and the rules in 33 other states. This rule change will conserve resources and improve the efficiency of both civil litigation and criminal trials. LB 494 updates the Nebraska Rules of Evidence to allow for custodian certification of business or entity records by an affidavit signed under penalty of perjury. Under the bill, before the trial or hearing, the proponent must give an adverse party reasonable written notice of the intent to offer the record and must make the record and certification available for inspection so that the party has a fair opportunity to challenge them on the ground that the sources of information or the method or circumstances of preparation indicate a lack of trustworthiness or otherwise do not fulfill the requirements of the business record at hearsay exception. This well-established hearsay exception allows parties to enter regularly compiled records within an organization so long as they meet certain criteria, including the documents being produced were not compiled just in anticipation of litigation, among other factors. One essential element is that the records have to be authenticated by a custodian of the business records. What has made Nebraska unique up until this point is that our rules have not allowed custodians of these regularly compiled records to verify them by sworn affidavit. This becomes an issue that adds costs, as often a business custodian needs to be flown in to testify to supply the needed foundation or authentication, rather, for the record. And especially during the pandemic, this became an issue that led to case delays when national companies, for example, social media networks, banks, or things like that, were not willing to send witnesses to come to Nebraska to testify when the pandemic was in the middle of the 2020-2021 era. This bill requires that in order to introduce the evidence, the custodian must complete an affidavit, a copy of which is replicated in LB 494, to attest that the records sought to be introduced do comply with the requirements of the business record exception. The attestation must be in the form of an affidavit, and it must be sworn to as directed in the form on pages 8 and 9 of the bill. I also want to stress again, under the bill, the proponent of the evidence shall give advance notice to all other parties of their intent to offer the evidence with authentication by affidavit, thereby allowing the opponent party the opportunity to question or challenge the evidence if they so choose. Additionally, the ability to demonstrate authentication by affidavit in no way, shape, or form does away with the ability to challenge the underlying business record with regard to their admissibility. For example, an opposing party can still argue that the records were created simply in anticipation of litigation and challenge their admissibility at a hearing, or they could also argue that the confrontation clause may apply to the proposed business records if in fact they're testimonial in nature, such as the results of a lab test for drugs. Following me, you're going to hear from Professor John Lenich, who will explain what the hearsay rule is in a bit more detail and what business records are. He'll describe why laying the required foundation is really merely busy work at times and show that is why the feds and other states have moved to the written certification approach that LB 494 takes. You're also going to hear testimony from a practicing attorney about how this modification would aid in the process of litigation. Happy to answer any questions you might have, and I would urge your consideration of LB 494.
Any questions from the committee? Seeing none, thank you for being here. Will you be here for close?
I will. Thank you.
First proponent. Welcome.
Thank you. Good afternoon, Senators. My name is John, John Lenich, Lenich. I'm the Earl Dunlap Distinguished Professor of Law Emeritus at the University of Nebraska and the civil reporter for the Nebraska Supreme Court Committee on Practice and Procedure. I'm testifying here today, however, as an individual citizen and not on behalf of the university or the committee. LB 494 deals with the hearsay rule. Now, we call it a rule, but it's really a series of statutes, sections 27801 to 806. And under the hearsay rule, a witness normally can't testify about oral or written statements that were made outside of court if those statements are being introduced to prove the truth of what was said. For example, a police officer in a bank robbery case can't testify that L told the officer that Barb robbed the bank. What L told the officer is hearsay. And why is hearsay normally inadmissible? It's normally inadmissible because it's normally not reliable. We don't know the basis for L's statement. We don't know what he saw or heard. We don't know where he was, and we can't cross-examine him because he's not in court. Now, there are quite a few exceptions to the hearsay rule, including one that's very commonly used. That's the business records exception in section 27803(6). The exception has two primary requirements. First, the record involves an event that occurs regularly in the course of the business's day-to-day activities. And two, the record was made at or near the time of the event as part of the business's regular practices. For example, a trucking company's service records for its trucks might be business records, or a manufacturing company's sales records. And the basic thinking behind the exception is that the records are sufficiently reliable because they're routinely made in the running of the business. Now, to prove the requirements for the exception, you normally need to call a witness who knows about the business's record-keeping practices and ask the witness some standard questions to establish that the requirements are satisfied. Most of the time, this is pretty routine, which is why I call it litigation busy work. LB 494 would eliminate the busy work by giving people the option of providing a written certification from a person who's familiar with the business's record-keeping practices. Now, when the bill was initially drafted, I suggested creating a form in the statute to be used for the certification, but I've since changed my mind because it's really tough to draft one form that would cover every situation. So I think general language would work better than the form. And we'll submit some written comments.
Thank you for your testimony, sir. Thank you for your testimony. Any questions from? It's not just you. I try to keep it at 3 minutes because we have some long hearings. If we don't keep it consistently, I can get in trouble or something like that. Any questions? Seeing none. Thank you for your testimony. Next proponent. Thank you. Welcome.
Good afternoon, Senators. My name is Scott Earl, SCOTTEARL. I'm here on behalf of the Nebraska County Attorneys Association. I'm a deputy Sarpy County attorney. I've been a prosecutor since 2014. I prosecute all types of felonies for Sarpy County. In that time, I've had many jury and bench trials in both the county and district court. I've come to speak in support of LB 494. As a prosecutor, we regularly receive records from numerous businesses that affect our cases. Due to the hearsay rule, those records are only admissible when a record keeper is able to lay the proper foundation for that record. Mr. Lenich spoke to you a bit about how the mechanics of the hearsay rule and exception work. I'm here to share how this has affected me in my practice, and also my office, and the Sarpy County taxpaying citizens. In 2020, my coworker and myself had a murder trial in which Facebook records were relevant to the case. To lay foundation regarding those records, we had a witness from Facebook come to testify. Initially, though, we ran into issues due to the pandemic and Facebook's refusal to permit travel for the employees to testify. This in part delayed trial at one point or another. Also, when trial did finally occur, Sarpy County had to pay nearly $600 for travel expenses and lodging for the individual that came to testify. I realize this is not necessarily a large amount of money, but still taxpayers should be able to save that money since these witnesses are not testifying about facts that are in dispute typically. More common, and I think this situation is going to become more common with digital evidence and just the volume of evidence that is coming about as records are more and more regular with digital components. I also had a coworker recently who was preparing for a murder trial in which he had difficulty getting cooperation from credit card companies and an insurance company while trying to prepare for that murder trial. It was difficult to get cooperation from the companies to provide a record keeper to come testify in regards to those records. I do believe this would save time in the courtroom and time of the individuals called to testify. In each trial, individual witnesses require time to testify on direct cross-examination and redirect examination. Even witnesses with relatively quick testimony may often end up taking 15 minutes, and especially when compounded with transition between witnesses. Also, there must be some flexibility in regard to when witnesses are called. These foundational witnesses are often required to spend their time waiting around for their opportunity to testify. This is especially wasteful for those foundational witnesses that must come out of state, like those employed by social media companies or credit card companies. I believe this would promote judicial efficiency by giving the judge the ability to consider the certification or affidavit as the evidence is offered. Both parties would have that ability to review the certification in advance, as well as the actual documentation as part of the discovery process and the rule as created. And then they can decide whether there may be a legal basis to question the validity of the certification. This would also benefit both sides. This is not necessarily a prosecution favored rule or defense favored rule. I'll take any questions if there are any.
Thank you. Any questions from the committee? Senator DeBoer.
Thank you for being here. Are these just for business records that are made into the normal course of business? Is there any sort of restriction on which business records? Or it's just all business records?
It'd be anything that would fall under the business record exception as far as the hearsay rule. So it'd be any sort of business record. Now, the confrontation clause still would be a valid challenge, as we heard. This wouldn't change anything about that. This would just give the judges the ability to say, we are okay with receiving this without actual testimony. But
So it lays foundation through an affidavit rather than testimony?
correct.
Perfect. Thank you.
Thank you. Any other questions? I don't like this bill. I'm like in the middle because it could help on business records for phones. I know everybody needs that, and in social media. But I just heard this bill yesterday about juvenile probation and police having access to it. And so where I'm trying to figure out the foundation concern. It's not a question. Just never mind. It's Friday. You're good. We'll talk. We'll talk later.
Okay.
I think I'll see you on the 15th anyway. So.
Yeah, sounds good. Thank you, senators.
Thank you. Welcome.
Good afternoon. Chairman Wayne and members of the Judiciary Committee, my name is Mike Guinan, MikeGuinan, and I'm the Criminal Bureau Chief for the Nebraska Attorney General's Office. I appear here before you today on behalf of the Attorney General Mike Hilgers in the Nebraska Attorney General's Office in support of LB 494. LB 494 would harmonize the Nebraska Rules of Evidence with the federal Rules of Evidence, streamline the process for litigants in authenticating evidence, and reduce the burden on the parties. Currently, the state rules of evidence require authenticating business records through testimony by a company's custodian of records. This can be incredibly burdensome. For example, we had a recent case in which records were produced from a company in California that the court found admissible at trial. We simply needed to have the appropriate testimony to authenticate the records at trial. In federal court, I could show authenticity by providing a sworn declaration from a custodian of records, attesting that these records are what they purported to be. Those declarations are made under penalty of perjury and are simple to execute and provide. Since this case was in the Nebraska State Court, we were not permitted to use a certified record for authenticity. Instead, we had to obtain live testimony. For an out-of-state party, that can be burdensome. In this particular example, my office spent weeks negotiating with the other side, attending court hearings in order to compel the testimony for what ultimately was a 5-minute set of questions to authenticate those documents. Had Nebraska had in place the federal rule, countless hours and resources would have been saved. For litigants in civil and criminal cases, whether plaintiff, defendant, prosecutor, or criminal defendant, having this rule would streamline the proceedings and save costs. In addition, Nebraska's rules of procedure and evidence closely follow the federal rules. And this legislature has adopted bills in previous sessions explicitly incorporating aspects of the federal procedure and evidence. For example, Senator Lathrop, LB 57, which adopted the present sense impression exception to the hearsay rule recently, that was signed into law in May of 2021. Additionally, then Senator Hilgers introduced unanimously passed a bill that incorporated Rule 56 summary judgment procedure from the federal courts into state rules. That harmonization, just like this one, would save parties resources. Lastly, it should be noted that Nebraska, mirroring the federal rules, has since 1975 to allow for authenticating foreign and domestic public records by providing a sworn declaration from a custodian of records under federal or under Nebraska Rules of Evidence 27-902, Section 4. For these reasons, the Attorney General supports LB 494 and asks that the committee move it to general file. I would be happy to answer any questions you may have at this time.
Any questions from the committee? Seeing none, thank you for being here.
Thank you.
Any other proponents? Moving to opponents. Any opponents? Anybody testifying in neutral capacity? Neutral capacity. Seeing none, as Senator Duncan comes up to close, there were no letters for the record. Senator Duncan, will close.
Thank you, Chair Wayne, and thank you again, members of the committee. It's Friday. I won't take too much of your time. Senator Wayne, I think you actually hit the nail on the head with sort of the balancing act we want to do here. It's complicated. It's hard. As you know, I was practicing and I'm currently a practicing lawyer. I was a public defender. And so the last thing we ever want to do is circumvent individuals' rights to challenge evidence. But we also need to keep into consideration and take into consideration some of the things that were brought up here with regards to difficulty getting people to show up, the fact that companies literally weren't sending people during the pandemic, and therefore evidence that would probably be admissible otherwise wasn't coming in. One thing I want to highlight is this bill does apply to everybody across the board. This is how evidence would apply for every individual trying to enter something into evidence. So the rule affects everybody. In addition to that, as was mentioned, it does put us in line with the federal rules of evidence, which generally I think makes a lot of sense. But I do want to make clear it is a complicated issue, and I do think we've struck a good balance here of protecting individual rights and being able to challenge the admissibility of evidence while still taking into consideration judicial efficiency. So again, I would thank you for consideration on LB 494, and I'm happy to answer any questions you might have.
Any questions from the committee? Seeing none, thank you for being here.
Thank you.
As that closes the hearing on LB 494, we will open the hearing on LB 576. Senator Cavanaugh. Senator DeBoer.
Welcome.
Good afternoon, Vice Chair DeBoer, Chairman Wayne, members of the Judiciary Committee. My name is Dave Sund, D-A-V-E-S-U-N-D. I'm the legislative aide for John Cavanaugh, representing the 9th Legislative District in Midtown Omaha. He's in another committee right now introducing a bill. He'll be here for close. Here today to introduce LB 576, which creates an affirmative defense to negligence and nuisance actions for properly permitted land management burns. A couple of years ago, Senator Cavanaugh had the opportunity to tour grazing lands in Nebraska and got to hear from landowners, farmers, and ranchers about the problems of eastern red cedar encroachment and the use of prescribed burns, or as Nebraska statute refers to them, land management burns, to prevent the spread of invasive trees. Nebraska law defines a land management burn as a controlled application of fire to existing vegetative matter on land utilized for grazing, pasture, forest, or grassland to control weeds, pests, insects, and disease, prevent wildland fires, manage watersheds, care for windbreaks, and conduct scientific research. Last year, Senator Cavanaugh introduced a bill, LB 953, that provided a limitation on liability for a properly permitted land management burn. The Trial Attorneys Association opposed that bill based on the language for the limitation on liability, and ultimately we were unable to reach an agreement before adjournment last session. LB 576 is an attempt at compromise language rather than a shield on liability, except in cases of gross negligence. LB 576 provides for an affirmative defense. This means that in a negligence or nuisance action arising out of or relating to a land management burn, if the defendant proves that they have complied with all terms of the permit for the burn, they would have a valid defense in court to that action. Land management burns are an important tool for grassland preservation, wildfire prevention, and for our farmers and ranchers. But legal uncertainty and the threat of lawsuits make it more difficult for landowners to utilize this tool on their land. The burn must be conducted according to a plan, the requirements of which are outlined in existing Nebraska Revised Statute 81-520.05. That section is not amended in this bill. The plan requires the name of the landowner, the name of the person who will supervise the land management burn if it is not the landowner, the land management objective to be accomplished, a map showing the areas to be burned, including natural and man-made fire breaks, procedures to be used to confine the fire in boundary areas without pre-existing fire breaks, a list of equipment that will be on hand, the types and conditions of the vegetative matter to be burned on the land and in adjacent areas, identification of roads and habitations that may be affected by smoke, a description of weather conditions believed to be required to successfully conduct the land management, including wind speed and direction, temperature and relative humidity, and such other information as may be prescribed by the fire chief of a local fire department. As always, Senator Cavanaugh is willing to work with anyone to make the bill better and address any concerns in good faith. Thank you for your time.
Thank you. Normally, we don't ask staff questions, but I talked to your senator. He said we can grill you all we want. So, no, thank you for being here.
All right.
Starting off with proponents. Any proponents? Proponents. Welcome.
Hello, Senator Wayne and members of the Judiciary Committee. My name is Crystal Stoner, and it's spelled K-R-I-S-T-A-L, last name Stoner, S-T-O-N-E-R, and I'm the Executive Director for Audubon, Nebraska. On behalf of the 12,000 members of Audubon, Nebraska, which is the state office of the National Audubon Society, we support LB 576 and request this be part of the hearing record. Audubon is a conservation organization focused on birds and their conservation, and we work to bring awareness to the condition of our environment and how changes impact birds, natural resources, our economy, and communities. Nebraska is a grassland state, and we are well known as the beef state, where cattle production is the largest segment of Nebraska's agriculture. What might be less known is that Nebraska is home to over 400 species of birds, and that our grassland birds have experienced a 53% decline, which is the steepest decline of any of the birds that we have studied since 1970. So as we look at both our ranching industry and our grassland birds are threatened as we see increasing encroachment from things like cedar trees. So since 2000, cedars have infested over 600,000 acres. And what that does is it reduces forage quality and it reduces habitat for birds as well as many other species. If we don't address this threat now, it's going to cost us $20 million every year just to keep up with that encroachment and not let it get any worse. So prescribed fire is one of the most cost-effective and efficient tools for restoration of our native grasslands. It helps prevent wildfires by keeping those trees at bay. Planned burns also recycle our nutrients, increase native plant germination, and they stimulate plants, so it actually increases forage production in many cases. Audubon has a long history of cooperation with the local fire departments and with private landowners, and we always support policies that empower local landowners as well as local fire departments. What this does is we find that We also find that the number one reason that landowners can be hesitant is because it's unclear to them what the liability situation would be. So if they're more confused and they're more hesitant, then we can't get these prescribed done as we need to. So LB 576 will reduce this significant barrier for landowners. So we encourage you to support LB 576. Thank you.
Any questions, Senator Blood?
Thank you, Chair Wayne. Just a quick question. I volunteer at Fontanelle, and you know that we do the prescribed burns at Millwoods,
Yeah.
right? I didn't get a chance to look at the entire part of statute. Would this pertain to like nonprofits, organizations, in addition to like public land?
I'm not a lawyer, but my understanding is it really clarifies and makes sure that if you follow the permit, if you have things in prescription, when you do the prescribed burn, then it's just going to give you more coverage should there be a lawsuit or liability. That's my understanding.
Had Senator Cavanaugh been here, I would have been able to ask him that question. So if he does come for closing, I'll ask that question to verify. So thank you.
Thank you.
Thank you. Any more questions from the committee? Senator DeKay?
Thank you. With your burn associations and stuff, when they go out to do a private burn or even a public burn, do they require or get a contract between the landowner or the park and recreations or whoever they're working for
Yeah,
in their association?
Usually, as we talked right before the hearing, it's usually a collaboration of landowners that are working together. So what's in place is more of just an MOU for that burn association on how we're going to work together. We certainly share our equipment and make it available for anybody to check out and use. In terms of that, it's the burn permit that comes from the local fire department. So that's the document that we have in hand that we all follow in terms of prescription.
So when they get a burn permit from the local fire department, do they have to list all the equipment and everything that they're using, or just the protocol that they're going to try it?
You know, that I'm not sure of. I can't speak to that specifics.
All right, thank you.
Any other questions from the committee? Seeing none, thank you for being here. Next proponent. Welcome.
Thank you. Good afternoon, Senator Wayne and respected members of the Judiciary Committee. Sorry. My name is Katie Torpy. It's Katie-Torpy, here today representing the Nature Conservancy. The Nature Conservancy supports LB 576. We are a leading conservation organization working around the world to protect ecologically important lands and waters for nature and people. We've worked in Nebraska for over 50 years, where we own and manage over 66,000 acres in the form of nature preserves and working ranches. Prescribed fire is one of the most effective and economic tools available to manage vegetation at a landscape scale. It helps prevent wildfires, of which 2022 was the second highest year on record for wildfires, so this is increasingly important. It also enhances agricultural land, restores native plant communities, and improves wildlife habitat. At the Nature Conservancy, we work with private landowners along the Niobrara and Platte to restore fire to rangelands and to combat the spread of eastern red cedar. Ranchers and the culture that has kept the sandhills intact are key to assuring that this landscape continues to endure. LB 576 creates a pathway for greater uptake of a tool allowing private landowners to achieve their land management goals in the most efficient and ecologically sound manner. Multiple benefits include killing invasive red cedar trees, suppressing the growth of other woody plants in the grasslands, improving forage quality in recently burned areas, and influencing higher plant diversity and habitat quality for wildlife and pollinators. These are impacts both biologists and ranchers want to see. Ranchers who have gained considerable experience with fire and are finding benefits beyond the control of eastern red cedar. Those include an ability to use fire to attract livestock to areas that are otherwise underutilized, and improving the utilization of forage plants such as little bluestem. In addition, they appreciate the enhanced wildlife habitat created by the fires. Now is the time to connect the dots of all the cedar control efforts currently underway with conservation agencies and landowners across the state. LB 576 provides needed clarity and will facilitate greater uptake of this essential tool. Thank you for your attention, and I'll take any questions if you have them.
Any questions from the committee? Seeing none, thank you for being here.
Thanks.
Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Bill Hyatt, BILLHIATT, and I am a resource conservationist with Central Platte Natural Resources District located in Grand Island. I am testifying in support of LB 576 on behalf of Central Platte Natural Resources District and the Nebraska Association of Resource Districts. The Central Platte NRD Fire Program began in 2004. It assists landowners within our district in planning, preparing, and implementing prescribed burns through different means, education and training, cost share, advice, or contracting. Through contracting, our staff will write the plan, work with the landowner on what preparation needs to be done, and our burn crew will implement the burn plan with help from the landowner. The ultimate goal of our fire program is to give landowners the knowledge and means to use prescribed fires safely using the best science, information, and techniques available. This proposed amendment will be a tremendous benefit to prescribed burners in Nebraska. Liability has been a constant concern to landowners and professionals alike. The amendment would provide reassurance that if you have done your due diligence throughout the process, planning, preparation, and implementation, that you are offered reasonable protection under the law. There is a great need for the expansion of the use of prescribed fire for many reasons, the main being woody species encroachment, eastern red cedar in particular. As has been seen throughout the Great Plains, grassland conversion to woodland has extremely detrimental effects on rangeland productivity and the loss of suitable wildlife habitat for endemic prairie species such as grassland birds. Fire is the most effective tool we have against this conversion, and with Nebraska being 97% privately owned, landowners are the ones that will be and are leading the effort. As a fire professional, my part is to provide those landowners with expertise and advice to accomplish their goals in a safe and effective manner. Thank you for the opportunity to testify, and I would be happy to answer any questions.
Senator DeBoer.
Thank you, Senator Wayne. So when we get these permits and the plans, they're not specific to a particular day, right? Because you have to have them open to a number of days when the conditions are right.
Yes, yep.
So go ahead.
So the process I go through is, once I have the burn plan completed, it's not required by law, but I give it to the chief that I'll be asking for the permit, and then he's familiar with it, and then can ask me questions about it. In the past, if they've had questions, I've met them at specific units and taken them around to show them what my plan is for it, and it really just depends on the chief on what he or she wants.
So if there's a range of days in which a person can enact the plan, let's say.
Yes. So we have our prescription, which is just a set of conditions that we want to be within. And that's usually to limit fire behavior to where it's not dangerous to us or anyone else, and to where we can actually keep the fire where we want it. That's the whole point of the plan.
So the plan does the plan list conditions like it needs to be winds out of the northeast or southwest or whatever, at less than this miles per hour?
So the basic plans what goes into every prescription that I write is relative humidity, wind speed and direction, temperature, and then if it's a particular, if I think it is needed, I'll add other things to that, but those four basics are what I include in every plan I write.
And so who sort of has the discretion to enact a plan and say, now's the time? We're within those things. Who's the person that does that?
So every burn has a burn boss, is what we call it. And so they will, keep an eye on the weather forecast and everything, and then they will gather the crew. And this is how it's done for prescribed burn associations also. They'll gather their crew and equipment, take weather measurements on site, usually using handheld weather meters, And then and then we'll conduct a test fire. And if all that is good, then we'll go. And that's in addition to getting the permit from the fire chief.
And what are the qualifications to be a burn boss?
There are professional systems out there that do that. For right now, like our program, we don't require that. We just want, and for landowners, it's more of a question of experience, comfort, and ability to lead.
Could anybody be a burn boss?
Yeah, so to me, fire is a learned skill, and anybody could be once they reach a point where they have the experience and ability to make the right decisions to keep everyone safe.
But but there's no specific credentialing that we have anywhere.
Not currently.
And so you create the permit.
No, I create the plan.
You create the plan.
Yep.
Thank you, sorry.
Yeah.
Someone else issues the permit.
Yeah, usually the local fire chief.
The local fire chief issues the permit,
Yep.
you create the plan, and then anyone else who feels that they're confident without any further credentialing can enact the plan by going and taking the meter readings to make sure that they're within the parameters that the plan has suggested.
No, so I mean, technically, yes, but for our program and the prescribed burn associations that I deal with regularly or that I've seen that are already established in Nebraska, it's a very organized thing. It's not just a random people showing up there. You know, we have meetings that we get to know each other. We discuss what we have going on, and leading up during the planning and preparation phase. I mean, that for like a large burn like the groups out west do, you know, that's 1,000 acres, 3,000 acres. That could be years ahead for that one day burn, years ahead of planning and preparation. So usually everybody's on the same page when we go out.
Okay.
Senator DeKay.
So where you're at, what's the average size of a burn for you in a day, and what's the size of the crew that does the burn?
So I actually looked this up just in case you guys asked. So in the last 7 years, our average burn size has been 70 acres for the eastern half of our district. For the western half, where we have active prescribed burn groups, their average is about 850.
850 birds or
850 acres per bird. And so some are larger, some are smaller.
And I would say that the preparation, that's just a comment, the preparation does go in because you gotta have the fuel for the burn, so land has gotta be set aside. So dead grass and stuff is the fuel you use. So there is a lot of prep going into it. And I'd invite anybody that wants to go to a prescribed burn to get involved and see how it works, and it's pretty interesting. And
so where do I sign up to be a burn boss?
You can come up to Knox County.
All right, I'm taking you up on that. You can be a burn boss. I used to get in trouble when I played with matches, so this is all new to me. Any other questions?
We tried to do that a little more organized than just playing with matches.
I did it at a scene, but I still got in trouble.
Yeah.
All right. Any more questions? Thank you for being here.
Thank you.
Why is this bill not a natural resource? Oh, okay. Welcome.
Thank you. And good afternoon, Chairman Wade and members of the Judiciary Committee. My name is Mark Goes, M-A-R-K-G-O-E-S. I'm a cattle producer, a past college instructor of 28 years, and a Nebraska Cattlemen member. I'm here to testify on behalf of the Nebraska Cattlemen, Nebraska Corn Growers Association, Nebraska Farm Bureau, and Nebraska Soybean Growers Association, and the Nebraska Pork Producers. I spent 28 years of my life teaching students animal science and range management concepts, including proper prescribed burn practices and utilization of those practices as management tools on their operations. I've witnessed how impactful land management burning can be in curbing the rapid expansions of eastern red cedar trees and other woody species overtaking the state's grasslands and rangelands. Over the years, I've had the opportunity to learn and teach others that prescribed fires are conducted with extensive preparation, planning, and careful execution. The burn plan requirements of a landowner to obtain the burn permit include the landowner's information, the name of the person who will supervise, be the fire boss of the land management burn, the objective to be accomplished with that burn, and a map showing the areas to be burned, including natural and man-made fire breaks, procedures to be used to confine the fire in boundary areas without pre-existing fire breaks, a list of equipment that will be on hand, the types and conditions of the vegetative matter to be burned on the land and in adjacent areas, identification of roads and residents that may be affected by smoke and fire, a description of weather conditions necessary to conduct the land management burning safely and successfully, including the wind speed and direction, the temperature, and the relative humidity. The local fire chief reviews this information to ensure the burn plan complies with the requirements and then determines if the land management burning will be conducted, placing necessary attention on the safety of the people and the property outside the burning areas. Today, I believe land management burning, also called prescribed fire, is a critical tool to assist ranchers in preserving and protecting our grasslands from the encroachment of cedar trees, other woody and undesirable species. Cited from the Central Platte NRD and Prescribed Burn Cost Share Program, the purpose of a prescribed burn is to control the undesirable vegetation, to prepare sites for harvesting, planting, seeding, to control plant disease, reduce wildfire hazards, improve wildlife habitat, improve plant production quality and quantity, to remove slash and debris and to add seed and seedling production, to facilitate distribution of grazing and browsing animals, and restore and maintain ecological sites. Ranchers routinely demonstrate that land management burning can be completed safely. LB 576 helps establish protection for the producer. It allows them to establish that the burn was conducted with extensive preparation, planning, and careful execution. Thank you, Senator John Cavanaugh, for supporting the landowners in their battle with woody encroachment in our grasslands and maintaining healthy rangelands. The organizations I listed in support of LB 576 and ask members of the Judiciary Committee vote to advance this bill out of committee. I'm happy to take any questions that you may have.
Thank you. Any questions from the committee? Seeing none, thank you for being here.
Thank
Appreciate
you.
it. Next proponent. Next proponent. Seeing none, we'll turn to opponents. Opponents. It's a great tie. I got the exact same one. Carolina. North Carolina colors. Welcome.
Thank you, Mr. Chairman, committee members. Dan Thayer, T-H-A-Y-E-R, just like Thayer County from Grand Island, on behalf of Nebraska trial attorneys, also a farm owner. So I know a little bit about cedar fires. So I want to share a few things with you. One, I have empathy for the ranchers and farmers in Nebraska that have cedar tree problems. It does encroach on their ground, pasture ground. It ties up millions of dollars, or excuse me, millions of gallons of groundwater. So I understand that perfectly. But this is why we are opposed to the bill. We hear prescribed burn and we think of a gentle, maybe 2-inch flame slowly going across the ground. This is just off the internet. This is
we don't use props, but I can get copies to everybody. So I won't take away your time, but can you get one of those and make copies quick? Thank you.
This is a common view of what a full-grown cedar fire looks like. And it's common for flames to shoot up 30 feet into the air and for embers to fly. These are big fires and they're dangerous. They're inherently dangerous. Current Nebraska law works. That's the second reason we're against this bill. Nebraskans sit as jurors, or we have judges who make decisions based upon negligence and reasonable behavior of the people involved if damage occurs or personal injury. Now, this bill last year was touched on that it tried to take the standard from ordinary negligence to gross negligence. Gross negligence, one of the definitions, near total disregard for the safety of the property or person of another individual. That failed, and it failed for good reason. This year, cleverly, the bill is amended to declare that if there's an out of control fire, it's an affirmative defense of the burning party who's following the burn plan. What's an affirmative defense? Very simply, if an allegation is true, an affirmative defense can block or limit the liability of that true allegation. Now here, if the burning party gets a permit and follows the burn plan and they burn down the house or the barn of the neighbor, they get to file an affirmative defense and say, I followed the plan. And as Senator pointed out just a couple minutes ago, there's major problems in regard to the qualifications of who can carry out these burns. And with an affirmative defense, a judge can limit or totally dismiss that case based on that affirmative defense. It's a bad idea and it gets worse. And that's because of the poor drafting that Senator DeBoer pointed out, and for some other reasons as well, including the time to carry out this particular burn. Finally, last year it was quoted, an Oklahoma State University study was quoted. Apparently Okie State keeps the largest database of control burns in the Great Plains.
Thank you for your testimony. I'm sure somebody will ask you a question. Senator Blood, followed by Senator DeBoer.
Thank you, Chair Wayne, and thanks for the fun pictures.
Yes.
Quick question, though. You're talking about affirmative defense, but doesn't that affirmative defense still need to be credible? So, I mean, it doesn't take away from the credibility, does it?
If you have the burn permit and the burn plan, and the evidence is that you followed that plan, they get to allege an affirmative defense, that they followed the plan, and that therefore can limit or absolve liability.
But, and I understand that, and I may not be phrasing this correctly. So doesn't the, because I am not a lawyer and I don't pretend to be, so doesn't the burden of credibility still fall on the person doing the burn when they go to court, though? I mean, we're saying that they have the competitive advantage, is basically what we're saying with the affirmative defense. But is there still not a burden for them to show that indeed with this piece of paper and whatever else they present for evidence, it still has to be credible?
When I file a lawsuit on behalf of an individual that lost their house or their farm in one of these controlled burns, and I make my allegations in writing, an answer is typically then filed afterward of the burning party who will allege, under these circumstances, an affirmative defense that they followed the burn permit and burn plan. Of course, in court, going directly to your question, they'll have to have credible evidence.
Right. I mean, because there may be things that are reasonable or unreasonable that sway it either way. Is that correct?
Correct.
Right. Thank you.
Senator DeBoer.
Thank you. I have a really great pun that I wrote down, so I really want to use it. Won't this have a chilling effect on prescribed burns? If we allow this affirmative defense, it's good, right? It'll have a chilling effect on the burns. If we do not allow some limitation of liability for them, what I've heard in the last year's hearing was that there are not as many prescribed burns as there should be for our land, for any number of things, from birds to whatever. And so we want to have something that sort of stops that chilling effect.
I don't know of the number of prescribed controlled burns in Nebraska in the last year, 5 years, 10 years. I know that it exists because I've seen them happen. And it's an ordinary negligence standard and the reasonable man standard. Our concern is that these limitations on liability, and this bill in particular, we believe is very poorly drafted, is going to then limit the liability when right now with a 99.3% success rate, according to the University of Oklahoma, why would we want to tinker with that? Few things in life have a 99.3% success rate. That's what's happening right now. That study was quoted in last year's testimony.
The 99.3 is
Success rate on prescribed burns and not getting out of control fires. So it's working now very well.
But what the testimony last year, I recall, was that there would be more prescribed burns, but folks are worried about liability if a prescribed burn, notwithstanding all of the work that they've done to try to make it as safe as possible. Everyone thinks it's gonna be fine, but it might go out of, it might get out of hand. Just that risk itself is that chilling effect. And so we have too few prescribed burns. We have land, we need to do a burn so badly. Red cedars have gone everywhere on it. I don't think it's chilling us. We just haven't gotten our act together to get it done. But if it would, we need to do it. It's something that needs to be done. So how do we help folks to do it in a safe way? I'm asking you, this bill is poorly drafted. You referenced my comments earlier. How do we make it better? There we go. There's my question. I got there eventually.
I'd be glad to get together with the sponsors of bills to come up with hopefully some reasonable steps. But going directly to your question, every activity has a chilling effect. 75 miles an hour down I-80 has a chilling effect for those that want to go 85 and 95. And so it's always a balancing test. And with the document that I gave to you, the exhibit, this is an inherently dangerous activity that needs limitations. We're not talking about 2-inch fires that slowly creep across grassland. These dry, mature cedars go off like little bombs, and they produce a tremendous amount of heat. The flames, I'm not exaggerating, 30 feet in the air, and embers are flying. It deserves to have a chilling effect so that the neighbors' properties and their safety from personal injury is not jeopardized.
Any other questions? Senator DeKay.
And I agree. Every spring we see fires like this where we do our burns. But if you have a burn association and you got the burn team out there with a new burn boss, where are we at as far as doing the right protocol as far as black lines, using riverbeds, roads to start your black line and have your black lines in place? One question I'd have about this picture, and I agree, we see them all the time, would be the fact, is this picture taken along the edge of the black line, or is this out in the middle of the burn where there's quarter mile, half mile burnt grass around it, where this picture was taken?
That picture was taken out in the middle of a pasture.
In the middle of the pasture?
Yes.
So there's a pretty good chance it was black lined all the way around it. So ash or embers were going to carry up past the black line.
I can't.
I'm not putting you on the spot, but when we're doing our burns, if we burn around, if this is going to be on the edge of a black line, or it's going to cause us a problem to get it out in a safe manner, we will work around that area and not include that in our burn line.
Well, with 93 different counties, whoever's counter you go up to for one of these permits and plans, the answer is going to vary significantly. And there may be, as the gentleman from Grand Island testified a couple minutes ago, may be very detailed. And there will be others that'll say, keep an eye on it. And with the type of fires that we're talking about here, we think this is a really bad idea in this bill, and that the system is working well right now.
Well, in my perspective, prescribed burns has got to be part of our land management, our pasture management, and I'm not saying it's 100% foolproof that something doesn't get away, but it's an effective tool. It's cost efficient, time efficient, and in regards to using mechanical eradication of cedar trees or chemical, we're talking about nitrates in water. So if you're using herbicides to eliminate the trees, then you have one more component that could be it going. So however we go, we got to keep going forward with burn associations and be able to help them be able to
I agree.
feel protected on how they do these burns.
I agree with you 100%. The burn of cedars is cost effective and it addresses a real problem in Nebraska. But current law is working. And the safeguards that are in under ordinary negligence standards is working for Nebraskans. You don't read about out of control verdicts or out of control court decisions on controlled burns in this state. You don't read about that of courts or juries making out of control decisions on prescribed burns. It's working. It doesn't need to be changed, in our view. Thank you.
Any other questions? No, I do appreciate the picture because I was thinking my grandfather had a farm and we used to go do a ditch burn, but it was never. So I was thinking like a little candle rolling across the, that's interesting. Good. Any other questions? I'm learning a lot today.
Thank you.
All right. Next opponent. Next neutral. Okay, no more opponents. Neutral testimony. Welcome. This is not banking. This is judiciary.
Different hat.
Oh, okay.
Mr. Chair, members of the committee, my name is Jerry Stillmock, Jerrystilmock, testifying on behalf of my clients, the Nebraska State Volunteer Firefighters Association, Nebraska Fire Chiefs Association, with over 9,000 members representing both firefighters and EMS. 5 quick hits if I can. Fire background recently, April 2022, 3 counties south of North Platte. It was the Road 702 fire. Over 1,800 people were evacuated in 5 towns. September 2002, Banner County, 4,300 acres. 50 volunteer firefighters were on the scene from over 15 departments. September 2022, that Sunday, Lancaster and Gage County volunteer firefighters were out all day and into the evening. Over 20 departments from Lancaster County alone. October 2022, the Halsey fire, 15,000 acres burned. August 2022, Carter Canyon fire, 9 days before it was under control, over 15,000 acres burned. 2012, go back a little bit further, the devastating year, over 500,000 acres were burned that year, 65 structures destroyed. Costs alone for firefighting purposes, $12 million. None of these were because a prescribed fire got out of control. I have to be perfectly clear. None of those were the situation. Why do I share that? Because it is dangerous. It is a dangerous profession. We know that because last year alone in Nebraska, 3 volunteer firefighters were killed in serving. In 2013, if you remember, 19 firefighters, federal firefighters, the hot shots, were killed in Arizona because of a wildland fire. It is dangerous business. This isn't new to the legislature. Senator Bob Wickersham started it in the 1990s, starting this discussion. Senator Annette DuBois carried that tradition on in 2002, 2015, 2007, 2015. Many hours of meetings, and legislation was introduced by both of those senators. Here's the hypothetical. Play with me just for a moment. What if that plan, and this is neutral, what if that plan was followed to a T? Everything right down the line, affirmative defense submitted, but you know what? Even though that plan was filed and submitted and carried out, 6 hours later, 12 hours later, that ember sparked, that ember blew, and it went on, and it killed somebody. Those are the things that are in front of you in terms of an affirmative defense and how that worked. The plan worked to a T, bingo. But then the ember was created. For Nebraska, for firefighters, both paid and volunteers, there's a fireman's rule. The fireman's rule, and that's why my associations are in a neutral position. The fireman's rule simply states that firefighters are out there, they have no cause if they are injured or killed in the line of duty as a firefighter because they look toward workers' comp. In the public safety, public service sector, firefighters are out there to serve the public, and they have no remedy except if the fire was caused willfully or wantonly. So we have no issues with liability. We have no issues of our safety. We have no issues of our equipment that's lost in terms of what about liability? I need to stop. The red light came on.
Thank you. Senator Black.
Thank you, Chair Wayne. Thanks for coming in, Jerry.
Senator.
But if they follow the plan to the T, and there's an ember, wouldn't that mean that they didn't follow something? I mean, if there's an ember that just like magically pops up, you probably didn't stick around long enough to make sure the embers are out. You probably didn't necessarily follow protocol. So wouldn't the burden then fall on you that you didn't do what was needed for an affirmative defense because the burden of you maybe missing something was part of that?
Perhaps. Best I could say, Senators, perhaps, and this is why. What do we say? We're from Nebraska. Hang on an hour, the weather's going to change, right? So I have the perfect burn plan. Nothing exceeds 5 miles per hour. You do not set that fire. It didn't. It didn't prescriptively before the fire. It did not during the fire, and it did not for 6 hours after the fire. The wind did not blow, and then something happened. The wind shifted, and that ember is ignited. A person is killed. The way I read it, in a neutral position, is where's liability go? Well, it looks like an affirmative defense because the plan was followed to a T. Your question rises perhaps to a issue of burden of proof and the standard of proof, rather than would it be an ironclad defense? Yeah, I could not answer it. The one final part of my answer to your question, please, is what other area of the law states that if a plan is followed, there is no liability? Senators, you made an excellent point in saying, well, what about Senator DeBoer made the point? Well, I'm going to stop because nobody asked me a question. I want to be polite as Friday.
Appreciate it. Any other questions? Senator DeKay.
So with the fire associations, are they willing to work with different burn associations to do the prescribed burns and help follow up the plan where they need to, that you're associated with? Or
Sir, that's a great question. If I understand your question is, will volunteer fire departments go out and be a part of the burn? And is that your question, sir? In some parts of the state, yes. Some part of the state, yes, that will happen. Some volunteer departments will go out there and actually carry out the burn itself. And while others, they will not be a part of it whatsoever, sir.
do the associations feel that prescribed burn is a necessary tool?
That's an excellent question, because that is what a group of 20 people, as we sat around discussing this legislation, pondered. Is prescribed burn a good policy? Complementing what Senator DeBoer said earlier. One thing that I haven't heard this afternoon is insurance is cost prohibitive. We all know that when negligence happens and an injury or death or loss of property occurs, there's usually insurance behind it. And these folks are able to get insurance, is my understanding. I haven't heard anything this year about prohibitive cost of insurance. Donna?
A lot of times with the association that we deal with, the private landowner that we're doing a burn for has the insurance in case something does happen. They sign off on that if there's a liability issue, they're putting their trust in us to do it the right way. But at the end of the day, if it does cross and burn some land of the neighbors or something, and something's going forward, that's where their farm or ranch insurance helps cover the cost of any damage that's done.
Yes, so the point I understand you just made, sir, is yes, the landowner is placed in jeopardy or is responsible, but it's actually the landowner's insurance carrier. So it's a question of insurance in my mind.
Any other questions from the committee?
Last question.
Oh, go ahead. Keep going.
Do you have any idea where Platteviews playing basketball this week? Just kidding.
Are you repping that game?
They wouldn't let him near the chip on Monday night.
Senator McKinney.
So if not, and thank you, Senator Wayne, and thank you too. If not an affirmative defense, well, even if we kept affirmative defense, would you be open to like some language that said unless you could show like the entities were willfully ignorant or reckless or something like that?
Yeah. Again, a great question, Senator. I got to keep reminding myself I'm here in a neutral capacity, Senator Cavanaugh. My understanding, that's what last year's legislation was, and there were groups that were opposed to that idea as well, sir. Will for wanton that's way out there, man. That's, I don't know how to respond to your question. It's well framed, but it is the public policy of having prescribed burn in Nebraska so you don't have these devastating 22,000 acre burns. Is it worth it to move to an area of willful wantonness in terms of negligence, to say the negligence has to be so extreme that only in the sense of willful wanton is a acceptable standard of negligence that would weigh that Nebraska wants to do more prescribed burns, so therefore we're going to reduce that standard of negligence to willful wantonness.
Because I guess the struggle is if somebody has a plan and they do everything to the T and something happens, that's kind of difficult. But if they just recklessly just burn and not, take into account the plan or anything, I understand that.
Another excellent point, if I may. We love 4th of July. We love January 1st. We love fireworks. For some reason, we are enamored with fireworks. But what happens if the city of Omaha approves a plan and that fireworks display is going on at TD Ameritrade at the ball field, and it nips CHI Center, and CHI Center has with that firefighting plan, that fireworks plan was approved by the city of Omaha. Should that fireworks company only be held to a standard of not have the benefit of affirmative defense and escape liability, not have liability? Because we followed the fireworks plans. Oh, the wind was coming out of the south. Everything was going toward North Omaha. I didn't mean that intentionally, but now the wind shifted, and now it's out of the northwest, and it's going to CHI Center. CHI Center. Is that the same type of thing you would do? I don't know, and that's why we wrestle with this. It's a big issue. Deaths happen.
All right, thank you.
You, sir, very good question. Thank you.
Luckily, both of them are ran by by Mecca, so nevertheless, thank you for being here.
Yes, thank you, Senator. Good day.
Thank you. Next, neutral testifier. Seeing none, as Senator Cavanaugh comes to close, there are 3 letters for record, 2 in support and 1 in neutral.
Thank you, Chairman Wayne. I apologize. I was in HHS. It seems to be whenever you have one bill, you get 2 bills at the same time. I really didn't hear most of the testimony because I got here late, but I'm sure you heard really what the need is. That prescribed fire, the reason I'm interested in this is that I got to go on a prescribed fire tour with Senator Geiger up in his neck of the woods about 2 years ago, and saw the results of that and the need for it. And you probably heard from the testimony, the groups that are interested in this, it is agricultural producers, cattlemen, corn growers, Farm Bureau, but it's also environmentalists. It is wildlife management folks. And the reason people want this is because it is the best way to recover land that we're losing to invasive species. As Senator DeKay pointed out, you can do it less expensively, you can do it without chemicals, and it really does help regenerate the land. And there are certain wildlife that is fire dependent, that their habitat's better when we burn the land. And so we're trying to find a way to do this safely and in compliance, but we're trying to help people who are willing to do this, which is the thing that we want to help people do, make it a little bit easier for them. I would point out just to, the stuff that I did here was Mr. Stillach's reference there. In that scenario, Senator McKinney, if you, in that hypothetical, if you continued with that demonstration after the wind shifted, you would be in violation of the plan, because the plan says the expected wind and humidity conditions under which you're going to perform it. And if the conditions were to change and you still did it, you wouldn't be afforded the protection of LB 576 because you were not going in compliance with the plan. You heard about how 90% of these are successful. Again, they're successful when they follow the plan. So the plan is relatively onerous, has a lot of requirements about the conditions under which you can do it, and the the resources you use when you do perform these things. You need a burn boss. You need the adequate number of people and the adequate number of resources, and you have to have the right conditions. I would also just point out that the requirements say that the fire chief shall issue the license unless they find that it can't be done safely. So they're not just going to issue this in any condition when they think that there are not enough people on the list, when they think that there's not the right equipment, and when they think that the weather's not going to be appropriate. So, you know, I could keep going, but I know it's Friday afternoon. I can get a few more bills. And two, I think the point about whether working with the trial lawyers, I would just say I have tried and tried and tried to work with the trial lawyers. I've sat down and met with them. I have offered meetings. I have offered alternatives to this bill, and I mostly get stonewalled on this. And so I'm at the point where I'm certainly willing to entertain their expertise on how to make this work in an appropriate way. But I will not just acquiesce and be slow walked on something. So if they're not genuinely interested in trying to figure out how to make this work, they're not going to be part of that conversation. And so that's where we're at.
Any questions, Senator DeBoer?
Thank you.
I'm sorry, send them to HHS if you can answer them over there since that was a more important committee than ours. Go ahead, Senator DeBoer.
So couldn't you use all of the information that you got a plan, that you were within the plan, that you got the permit? Couldn't you use all of those as a defense now?
I think that would be relevant information in a trial if you're going to get to that point, but this would just give a little bit more protection to people who are following through with doing what we know is best practice. It's basically establishing a standard for which people are supposed to perform, which we would find that you're not going to be negligent or liable.
So it establishes a standard, but plans aren't standardized, we heard. And a burn boss isn't standardized as to what's required. Is there a way to develop a standardized requirement for burn bosses and a standardized requirement for a plan that would allow?
I think that would be, I think that's certainly possible. And that might be something, somebody on the committee might have more expertise about than I do, and certainly some of these other folks, about whether those are, how exactly to go about that. But I mean, that to me is a very constructive suggestion.
Because if there's just an unstandardized thing, if you have this unstandardized thing, you could have one end of the spectrum or the other in terms of being a very good plan or not a great plan. And if they have the same weight of law, you can use a good plan for an affirmative defense as well as you can use a bad plan for an affirmative defense.
Well, and as you heard, I think that there's a possibility of that, of course, but the fact that they have to be issued by the local fire chief and they have an interest in these fires not getting out, they're going to hold to a standard. They're going to hold them to as high a standard as they probably can to make sure they're not going to get out. But I don't think it hurts to create a uniformity, at least a minimum standard that needs to be followed. I wouldn't have any problem with that. I don't have the expertise to make that standard, so I'd be happy to entertain anybody's suggestions on how to do that.
Because we don't want to have a chilling effect on prescribed burns, right? Okay, thank you.
Senator Holcroft, followed by Senator DeKay.
Thank you, Chairman Wayne. I was just curious, does the Department of Agriculture play any role in this, in the coordination of the overall strategy of where to burn, when to burn?
The State Department of Agriculture?
Yes.
I don't recall that they do. I think the U.S. Department of Ag has some kind of programs for doing it, but I'm not aware of the State Department of Agriculture playing in it, but I can check on that for you. Thank you.
Senator DeKay.
I wished I'd been able to ask this sooner or thought of it sooner. In a thumbnail, what is the differences between this bill that's presented this year and the one that was presented last year?
That's a great question, Senator DeKay. I was sitting here trying to recall. So last year, we wrote this bill in response to the criticisms we received from the testifiers last year. And I guess didn't figure it out with them, despite the fact that we tried to work with them in the intervening year to alleviate their concerns. But last year would have been just a more broad immunity for folks when they followed. Basically, just would have been a blanket immunity if you followed the prescribed burn plan.
Right.
So this would probably be considered. Intending it to be a step back from that. I guess maybe we haven't gone far enough. Step back far enough.
Thank you.
Any other questions? Senator Blood.
Thanks, Chairman Wayne. I don't think he expected so many questions on this, so, but that's what
No,
happens
I
when you
did
don't
not at
show up
all.
with an introduction. We have to ask you questions at the end, so it
that's why I
slows
came
us
back.
down.
It's because of my high level of respect for this committee
So
that I came back.
Nebraska Game and Parks, like 9 years ago, put together the Nebraska Prescribed Fire Council. You're aware of that?
Yeah.
And they had meetings with stakeholders, talked about prescribed burn techniques and fire prevention. What data were you able to glean from all of their work that helped you with this, or that you think that would be beneficial?
Oh, well, I mean, I guess I couldn't answer that question at the moment. I don't have the data for me. I don't know who testified earlier. Did you have the testimony about the University of Oklahoma testimony from last year? You weren't here last year. I can't ask you a question, I know. But I'd have to get back to you on that one.
Okay.
Is there a question from the committee? Seeing none, thank you for being here.
Thank you. Have a good
Let's,
weekend, everybody.
committee, let's keep this engagement going with our great questions. Next is, as we close the hearing on LB 576, we will open the hearing on LB 139, Senator Brandt. And I want to thank you for being in our committee, and I appreciate you being here. You showed up early to see the dynamics. I really appreciate it.
I didn't want to miss the burn bill for the second year in a row.
Welcome.
Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Tom Brandt, T-O-M-B-R-A-N-D-T. I represent Legislative District 32, Fillmore, Thayer, Jefferson, Saline, and southwestern Lancaster counties. Today, I'm introducing LB 139, which would increase the jurisdictional amount for small claims courts. Small claims court allows for disputes to be resolved quickly and inexpensively. It grants citizens access to the court system for the type of cases that otherwise would likely not be worth the expenses and effort of seeking out and hiring legal counsel. For these types of cases, even finding an attorney willing to take them would likely be challenging. This is especially true in Nebraska, where the current jurisdictional amount for small claims court is $3,900. Nebraska currently ranks 47th among states for small claims jurisdictional amounts. As a result, small claims cases have dwindled from 4,977 in 2012 to 2,314 in 2022. There were 62,066 civil cases filed in 2022, showing that small claims filings represent a very small portion of the total cases filed. Even if we doubled the amount of small claims cases next year, it would be fewer small claims court cases than just a decade ago. Prior to bringing this bill, we reached out to several organizations, most of which believe this is a good idea. There have been conversations with the Nebraska State Court Administrator about the impact on county judges. They expressed a concern that raising the jurisdictional amount immediately to $10,000 would strain the courts. We plan to work with all of the stakeholders on an amendment that would lower the amount to address their concerns. The fiscal note, when you look at that, does reflect that we may have to add some staff if it's increased $10,000. Part of the amendment would be to adjust the jurisdictional amount using the Consumer Price Index from every 5 years to every year. If you just look at the data, it is obvious that our small claims court jurisdictional amount is too low. This impedes the ability of individuals and businesses to access efficient and cost-effective resolutions for small disputes. LB 139 is a bill that can address this issue. And if I learned one thing in serving 4 years on the Judiciary Committee, it is this simple statement: justice delayed is justice denied. With that, I would be happy to answer any questions.
Any questions? Seeing none, thank you for being here. You want to sit up here in honor of being a former chairman? Okay. Welcome.
Thanks for having me.
Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Adam Feser, Adamfeser. I'm the Director of Cooperative Advancement for the Nebraska Cooperative Council. Council represents the interests of agricultural, rural, electric, and telephone cooperatives in our great state. Several months ago, we had a member reach out to see if the council could do anything about the small claims jurisdictional amount. $3,900 is just too low. We surveyed our members and a clear consensus formed that increasing the jurisdictional amount would be beneficial. I spoke with Egg Valley CEO this morning, and he said that having a no-cost option to settle disputes is important. In the egg world, $3,900 does not get you far. As I heard from various folks when calling around about Nebraska's jurisdictional amount, you can't even settle a dispute over a fender bender for that. So we began investigating, and indeed, Nebraska lags far behind most of our country in our small claims limit. The handout I provided shows jurisdictional amounts for 50 states, Washington, D.C., and some U.S. territories for the sake of comparison. Some states have counties mixed in, but this is a pretty good representative piece of data. When I began reaching out to organizations and individuals, including businesses and small business organizations, nonprofit entities, attorneys, legal organizations, most folks seem to agree that we need to increase the jurisdictional amount. They also said it's not a top priority for them, but the tenor was generally supportive. Small claims court broadens access to the court system and the justice it provides. So the limit you set should reflect the reality of what constitutes a small claim. It's also clear that simply using CPI to adjust every 5 years is not sufficient. Small claims limit was set at $3,500 in 2010, and it's only increased $400 since that time. With a broad consensus that $3,900 was too low, Council reached out to Senator Brandt. We appreciate him bringing this bill. Council originally decided $10,000 was the correct limit to pursue. This is the most common limit in the country, very close to the national average, and makes intuitive sense. But after meeting with the court administrator and a few county judges, it became clear they were concerned $10,000 would increase their caseload too much. As Senator Brandt mentioned, we're willing to work to find a compromise to address the issue. Ideally, that compromise would move us closer to the national average, which is about $8,700. I looked into small claims in cases in a neighboring state, Colorado. Their jurisdictional limit is $7,500, and in 2021, they had 4,561 small claims cases. And that's despite having a population nearly 3 times the size of Nebraska. As Senator Brandt pointed out, the number of small claims court cases has steadily been decreasing. The handout I shared has data for small claims cases going back to 2007 in Nebraska. And as you can see, there were substantially more small claims cases then. From 2007 to 2012, there were far more small claims cases. That statute had set the number of county judges at 55. As I read it, the courts were able to handle a much larger amount of cases with 3 fewer judges than they currently have. Information in the fiscal note does not appear to be supported by the experience of our neighboring state, Colorado. It is certainly not supported by the national average of small claims jurisdiction as set forth in the handout. As it says in the Nebraska Judicial Branch website, small claims court provides a prompt and inexpensive way to resolve, and I will.
Thank you. Any questions from the committee? Seeing none, thank you for being here. Next, proponent. Proponent. You didn't wait this long, I testified. Proponent. Okay. Moving to opponents. Oh, proponent? Yes. All right. See, I convinced somebody. Get up and go. There we go. Welcome back.
Thank you, Senator. My name is John J.O.H. Lenich, L-E-N-I-C-H, and I support the proposal to raise the small claims court minimum because it would allow individuals with smaller claims to be able to bring them without hiring a lawyer or try and handle the case themselves and deal with the complicated aspects of the formal rules of evidence and procedure. And although 10,000 sounds like a lot, it really isn't these days anymore. If, for example, we have a dispute between a carpeting store and a homeowner is saying you didn't put the flooring in the right way or didn't come forward, that case is going to involve putting new flooring in $5,000 easy. So again, there is a real limitation, I think, on the ability of people to seek redress when our small claims court maximum is only $3,500. And there is another possibility too, while the committee is considering this issue, might consider raising the amount in county court from $57,000 to perhaps $75,000. And that would tie in very nicely with the County Court Civil Expedited Civil Actions Act that the legislature passed in 2000. and that took effect last year. It aims at personal injury cases, and it's a really nice system with a very good set of court rules that the Supreme Court has adopted. And there are those cases that, $60,000, $70,000 in personal injury. Again, that sounds like a lot, but in the way things are today, it's really not. And therefore, I would support this bill and encourage the committee to consider raising the county court jurisdictional amount. Thank you for your attention.
Thank you. Any questions from the committee? Seeing none, thank you for being here.
Thank you, sir.
Any other proponent? Seeing none, moving to opponents. Welcome.
Good afternoon. I am C. Joe Peterson, that's C. Jopetersen. I'm a county judge in the 5th Judicial District, and I'm here on behalf of the Nebraska County Judges Association in opposition to LB 139 as introduced. The increase in the jurisdictional amount from $3,900 to $10,000 or even $7,500 causes concern to the county courts. While we do not oppose some increase in the jurisdictional amount, and we're recommending that increase be $5,000, we strongly believe that the substantial increase sought would result in consequences which would be detrimental to the courts. Such an increase, we believe, would cause both a fiscal impact, filing fees may have to be increased and additional judges added, as well as judicial time impact on the county courts. Small claims cases take more time than many civil matters, and the weighted caseload reflects that. Small claims cases are given 30 minutes, civil cases 8 minutes. That case weight would most likely go up with an increase in the jurisdictional amount, as the more money involved, the more complex the case. When, as with our small claims cases, the parties are self-represented litigants, as attorneys are not permitted in Nebraska on small claims cases while they are in our surrounding states. It's simply a fact that more time is needed by court staff and judges to process these cases. Additionally, the very nature of small claims cases is to allow a party to pursue a claim against another party without having to hire an attorney. The substantial increase in the jurisdictional amount may well result in defendants responding with counsel and making it harder for plaintiffs to have that access to justice the small claims court is in place to provide. More time spent on more cases and more complex cases due to the increase proposed would also likely result in county judges having to decrease the time we spend on the wide variety of the other cases we're required to handle. Increasing the jurisdictional amount may also affect the availability of mediation at no cost to the parties, which we believe is an important tool to the small claims process. There are simply too many unknown factors to determine exactly what consequence would result from an increase of 2 or 2.5 times the current jurisdictional amount. There's no question that a shift of civil cases to the small claims docket will result in an increase of workload for county courts. Without any way to gauge how significant the shift of cases will be, and as a result, how significant the increase in judicial time spent on small claims cases, the county judges believe it would be more efficient and prudent to increase the jurisdictional amount in a smaller increment to allow the courts to then monitor the consequences, the judicial time spent, and the fiscal effect an increase may have on the county courts. Again, our recommendation would be an increase to $5,000 and a requirement for mandatory mediation when available. Both would allow the courts to ascertain over a period of time the judicial impact for time and the fiscal impact of such an increase without causing an undue strain on the judiciary and the requirement of additional judges to handle the increased caseload. I'd be glad to answer any questions.
Thank you. Any questions? I mean, I just need to understand. So if small small claims, if they come in with an attorney right now, it goes to county court.
They can't.
No.
Yeah.
If I file a small claim
If you
against
file,
Sen Ernie
the other
Chambers,
side
he
comes
comes
in
in with an attorney, it goes to
they
county
have to
court.
transfer it to civil court.
So that's already an issue now, right? So that issue doesn't change just because.
No, well, if the amount goes up, then I'm guessing more defendants might hire counsel.
So the problem that I'm seeing really across the state is that attorneys aren't taking cases because they are only like 7,500. And so if it's 7,500, let's say property claim, you hire an attorney, you're going to spend a significant amount of dollars just having the attorney So attorneys are declining now. And so these
I
people
don't know
are,
that we see that in rural Nebraska.
that's what that's what I'm trying to flesh out here. Is it more of a big 3 county issue versus rural?
I know that there are a lot of small claims in Douglas County.
Yeah, that's what
I talked to my brother in there and they handle a ton of small claims cases.
Okay, I'm just thinking.
So whether or not it's the dollar amount, whether it's not it's attorneys that don't want to take those cases because they're $7,500, I'm going to charge you $5,000 or $2,000 to do that. It's not cost effective.
It's not cost effective. And then on the flip side, as an attorney, and you know this too, having pro se counsel while the courts are supposed to treat them the same, we always try to give a little leeway because they're not attorneys. So it does make it harder from an attorney's perspective sometimes to deal with pro se because you can't. So I'm struggling with this as I'm thinking out loud. But I'm just trying to, I know there's going to be a little bit increase of work, maybe more out in rural, but this is an issue where 3,500, like, we turn out a lot of clients for 35 or even 5,000 or 7,000 because, and I tell them it's cost prohibitive. You have a property damage for a car that's worth 7,000. You need that car to transport your kids around. You need to get as much money as you can, and by hiring an attorney, you're not gonna get a replacement value of your car at 5,000 because your attorney took 2. So how do we balance that is what I'm trying to figure out.
Along the same lines, I'm telling you that if you add that much money to the small claims docket, you're just going to increase the time county judges spend on small claims. They take a lot of time.
So yes.
I mean,
I've
that's
been
the
stuck
real
behind
issue.
a lot of those hearings, so I understand. Okay, thank you. I'm just thinking through it. It's Friday, so we get to think out loud. Okay, thank you so much for being here.
Thank you for your time.
Next opponent. Welcome.
Good afternoon, Chairman Wayne, members of the Judiciary Committee. My name is Tim Haruza, last name spelled H-R-U-Z-A, appearing today in opposition to LB 139 on behalf of the Nebraska State Bar Association. Judge Peterson did a really good job of sort of outlining the concerns, and I also think the fiscal note does a pretty good job of highlighting the 2 things that I want to talk about today. The Bar Association has absolutely is absolutely in support of increasing the number here, right? So I think the lawyers that we've heard from and the discussion that we had in our committee meetings throughout this process, and the cooperative council was good enough this last fall to reach out to us. We've been grappling with this conversation for several months now. Raising the number makes sense. 10,000 is a pretty substantial jump compared to where we are. And the concern from our end is really a strain on judicial resources in light of the purpose the small claims court is designed and meant to serve. So let me start maybe with that second part. Small claims court serves an important purpose in allowing people access to the courts, as we've all discussed here. It's an expedited process that doesn't include attorneys, that has a limit in terms of the amount of money that you can recover to have jurisdiction. Along with that, though, includes reduced filing fees, and as Judge Peterson explained, and as the fiscal note alludes to, additional court time. We're always cognizant of court resources and the hours in the day that we have for our judges to use. These types of cases, as you've mentioned, Mr. Chairman, are fairly intensive because they're pro se versus pro se. We think they serve a place, but I think the other additional piece is that it's meant for those folks who need to come into court to have an issue resolved between the parties. What we have always been strongly opposed to, and I think it probably goes back a little more than 10 years ago, the last time that we've touched this issue, we don't want it to become a collections court. And so we presently have a cap of, I think, 10 cases per year that an individual can use the small claims mechanism for. If you have those limited instances, it makes a lot of sense. And that's why we're open to an additional jurisdictional amount. But if you're talking about increasing it to $10,000, and I know we're not messing with the number of cases that you can file in a single year right here, but when you start talking about $10,000, you start getting some real controversies that probably ought to be, or start to look like they're being handled in a more professional or in a more corporate way, right? As opposed to parties who need to get into the court to have a judge resolve a dispute between them. With that all being said, I'm happy to answer questions. I know we're short on time. This is one of those things where we are open to negotiations. We have good conversations with Senator Brandt, with the representatives of the Cooperative Council. Lawyers understand that the number should probably move up. I don't know what that number needs to be, but at this point, $10,000 is very concerning to us in terms of how it affects the court.
Any questions from the committee? I guess my concern is if the thing is about access to court, I would say $10,000 and below, there's a lot of people who aren't accessing the court because of the situation I just described with the honor here that $3,500 to $10,000. How many people are not accessing the court from that? You don't know the answer to that, but my question is there, if the fees at $29, why can't you do a sliding scale to 10,000? So at 10,000, if you have a $10,000 claim, why couldn't you make that the regular $49 a fee? So you can go 3,500 stays the same at $29, and then you go 3,500 to 7,000, $39, 7,000, 10,000, $49. That would solve your funding problem.
Yeah, definitely from the filing fee standpoint, and that's sort of where I think too, we're definitely open to additional costs. I know the judge testified that maybe $5,000. I know that we've had conversations with Senator Brandt about potential other numbers. I think the concern for us is, and admittedly, we've been where we are for so long, but a large scale jump like that will have an impact, and it's unclear what that would be. Whether you stair step that in, whether and again, if you go back to when this was last visited and they put the cost of living adjustment piece in, that allows the court then on its own, the Supreme Court, adjusts by cost of living up from that $3,500 that's set in statute. So right now it sits at $39. That only happens though under the statute every 5 years. I think we would absolutely be open to doing that more often, more regularly, on a regular basis to ensure that we're talking about the jurisdictional limit advancing as costs or as those things change too more frequently. So
I understand that, but down here, especially in judiciary, there are tons of bills that are advocating for new penalties. That's going to increase time with judges. The argument of time that judges have to work on cases, particularly misdemeanors and county judges, at least my time here, you've never argued, the bar on behalf of courts have never argued that increased penalties will also increase time with judges and we should hire more judges. So why is this different?
I would tell you that we rely strongly on the time study and the weighted caseload study that's conducted on a regular basis, and the court that gives us feedback as we continue to add additional time and those sort of things. I think that's what you see reflected in the fiscal note as well, which is, hey, if you put 10,000 more cases on the judges, that weighted caseload is very likely then, if you raise it to $10,000 and then you see additional case filings come in, that weighted caseload is going to demonstrate that we have a need for more judges, which will result then in additional resources. I'm not here necessarily saying that I oppose adding judges if we need them, right? I'm here telling you that under the current structure that we have, when you go up in such a big chunk, you run the risk really of straining the resources of the court, but then also, as I mentioned before, maybe overstepping a little bit of what the intent of that small claims jurisdictional amount and what that avenue for recourse was kind of designed for.
Okay, but we just had an amendment on the floor today that added 5 more misdemeanors on a gun bill.
Right.
That's 5 more cases times 4 people in a car. That's 20 more sightings. The judicial branch has never raised that issue of more criminal cases that need more judges. So why is it when we're increasing access to court for people? Here's our problem. You go into the hospital, you get in a car wreck, go into the hospital. Your car is only worth $3,500, maybe not even that much. But your hospital bill, if they do an MRI and an X-ray, is going to be $1,000, $2,000. So you're putting somebody in a position that they have to go litigate an $8,000 claim to hire an attorney, of which the standard is 1/3. And let's say they give them a break and go 20%. That individual comes out with nothing. They're actually in the negative. So the best option for them is to, and I tell this all the time to my clients, hey, you'd be better off trying to work with the insurance company and file it yourself. Your claim's only worth $5,500, $6,000. Like, don't pay me to do that.
Well, in a free-flowing conversation,
Yeah,
this one maybe getting a little bit outside of where I intended to testify today, but I also think to that comment, Mr. Chairman, and the judge sort of alluded to this before earlier, and I'm sure you kind of are familiar with how it works, but when you start getting into those higher amounts too, the defendants in those cases for $8,000 or $9,000 are far more likely at that point to go get an attorney, and then you just remove it to civil court anyway, right? I guess that changes in that situation. If you go hire, if the defendant hires an attorney to stop themselves from getting an $8,000 judgment against them,
Right.
because when you get to those amounts, it might be worth finding a defense attorney.
So you walk me
It
right,
shifts who's paying the fees, but then you remove it
so
anyway.
you walk me right into my
But-
point. If I file a claim, if I have somebody file a claim against an insurance company or against their neighbor who has insurance, they're gonna remove it to civil court. So we're not talking about that much time for a $10,000 claim or less.
Maybe for those types of cases, sure. Yeah, for those that have, where insurance is involved or where it's those types of cases.
I'm
Still
just
have a
concerned that
removal
there's a gap that
process.
people are not filing cases because they can't get counsel because it just doesn't make economic sense. You actually put your client in a worse position. And $10,000 and below are typically those claims. That's my.
I don't disagree with your sentiment. I just don't think the 10,000 and below is the number. I think it's somewhere in between the current 3,900
So like
and the 10,000 that's proposed.
9,999.
And 99 cents. Yeah.
All right. Any other questions from the committee? All right, we'll talk about this. Thank you for being here. I appreciate it.
Thank you, Mr. Chair.
Next, I did. Before that. Opponents. Any other opponents? Seeing none, we'll move to neutral testifiers. Welcome back, Mr. Steele. Welcome.
Thank you, Chairman Wayne and members of the Judiciary Committee. I am Corey Steele, Corey Steel, and I am the Nebraska State Court Administrator. I want to thank Senator Brandt for taking the time to talk with us at the Court Administrator's Office regarding this bill. I'm here in a neutral capacity just to provide some more information and some feedback based on the conversation that Senator Brandt and I have had and that we've had with the cooperatives and the county court judges. I'll try to stick to components that haven't been addressed by Judge Peterson and Tim Perusa. One of the things that we've talked to Senator Brandt about is one of the things, Senator Wynn, you were hitting on is the judicial increase. With this bill, we took a look at all of these civil cases that had a judgment between 4,000 and 10,000, and how many of those could potentially then would have maybe been in the small claims. Could have, right? This is not a guarantee. This is not an exact science. But how many of those could have potentially been in the small claims if the jurisdictional limit was 10,000? That would estimate about 36,384 cases last year. And again, as Judge Peterson discussed, the average case time for a county court judge with civil cases is 8 minutes. For a small claims case, it is 30 minutes. So it's a mathematical equation of it. It's going to increase judicial time. We also, one of the things Senator Wayne was hitting on, we don't know how many new cases would come because people don't come to court for $3,900 at this point. It's not worth their time, energy, effort. Raising that jurisdictional limit, we would see new filings. That's unestimated. We don't know how we would come up with that number. To answer Senator Wayne's question as I was listening, Douglas County obviously is our largest. Douglas County itself in the county court has roughly just shy of 10,000 small claims cases currently last year. That jurisdictional would potentially double in Douglas County if it was raised to the 10,000 limit. The other in our fiscal note that Tim Perusa did a good job and Judge Peterson is the filing fees. And that's something that potentially can be or could be adjusted if the legislature felt the need to do that. One of the things that we have discussed with Senator Brandt is changing subsection 4 of 25-2802. So it wasn't every 5 years to be adjusted by the CPI. Maybe that should be done annually by the Supreme Court. So that would increase at a faster rate and it would stair step so we could then determine and have more flexibility. With that, my red light's on. I will take any questions that you may have.
Any questions from the committee? So if we get 1.2 million solves the problem, that's what the fiscal note says?
On this bill, I don't believe we put an exact number. We said the potential for 2 additional judges across the state.
Okay. All right. Well, I'll leave it to Senator Brandt and you to figure out all that. So thank you. Any other questions? Seeing none, thank you for being here.
Thank you.
Next, neutral testifier. Seeing none, as Senator Brandt comes to close, we have 1,400 letters for the record. No, just one letter for the record, one support, and one letter of support. Welcome back, Senator Brandt.
Yep, thank you to all the testifiers today. Like our only proponent testified, Nebraska, it has one of the lowest in the nations. We're 47th at $3,900 today. Judge Peterson hit on the filing fees. Today it costs $29 to file in small claims. It costs $49 to file in civil court. That could possibly be raised. I know last year the committee had a bill in front of them to raise a bunch of stuff. 30 minutes versus 8 minutes. 30 minutes on a civil trial, 8 minutes on small claims. And while it's true there's a time difference from the court standpoint, on that civil 8 minutes, you have 2 attorneys sitting there and the clock is running. So I mean, the cost is simply transferred from the courts to the attorneys. We will be at $4,900 in 2 years anyway with the way the current bill is written, because the CPI adjusts every 5 years. So taking this to $5,000 instead of $10,000, I know some of the parties are looking at that. I think realistically, in talking to all the parties, we're somewhere between that number and possibly 7,500. We're working with all the parties. We agree with the Bar Association. We do not want this to be a collection agency. We did not change the 10 limit per business. We agree with Mr. Steele about possibly adjusting the CPI annually versus every 5 years. And I guess I'd just like to make this final point. At the current rate we're going, in the last 10 years, we have less than half of the number of small claims that we used to have. We're down to 2,300. In another 10 years, it won't make any difference anyway. There won't be any small claims left in the state of Nebraska if you trust that current slide that we're on. So with that, I'd be happy to answer any questions.
Any questions from the committee? Seeing none, thank you for being here.
You bet. Thank you.
That closes the hearing on LB 139. We'll IPP that later today. And we'll move to LB 767, Senator DeKay. Welcome to your Judiciary Committee. We don't have sponsorships up here. Go ahead.
Thank you. I gotta warn you right now, my voice is only gonna hold out for about another hour and 13 minutes.
All right. Good.
Chairman Wayne and members of the Judiciary Committee, I am Senator Barry DeKay, spelled DARRYDEKAY, representing District 40 in Northeast Nebraska, and here today to introduce LB 767. I am bringing this bill on behalf of the Nebraska Commission of Public Advocacy, or NCPA. LB 767 would increase the indigent defense fee from current $3 to $8 for cases filed in Nebraska courts. The purpose of this increase is to ensure that the NCPA is properly funded. Before the commission was created, private practice lawyers from Omaha, Nebraska, Omaha and Lincoln were usually appointed to represent indigent defendants charged with murder in Nebraska's smaller counties. In most counties, court-appointed attorneys in murder cases are paid
around $125 an hour or appointed more per hour. In typical non-death penalty murder case, court-appointed counsel will often bill the county at least $100,000. In murder cases in which the state gives notice of its intent to seek the death sentence, court-appointed counsel may bill the county considerably more than $100,000. Since the Sixth Amendment of the United States Constitution and Article 1, Section 11 of the Nebraska Constitution grant the right to an effective assistance of counsel, it is financially prudent for defendants charged with offenses such as murder to have an experienced lawyer from the beginning of the case rather than risk an appeal or challenge resulting in a new trial and all of the costs that would entail. The NCPA was founded in 1995 with the purposes of providing indigent defense counsel for certain crimes, thus saving counties taxpayer money. The commission was created in part because of the Richardson County's experience in paying court-appointed defense counsel in the two high-profile murder cases. Number one was the 1985 Rulo cult murder, and number two was the 1993 Boys Don't Cry triple murder. Richardson County reportedly spent over $1 million on those cases and had to take out a bank loan to pay court-appointed lawyers. As a result, Richardson County nearly went bankrupt. As I noted previously, these types of cases can be very expensive to defend. The cost for defense of a case always goes to the counties unless the commission handles the case. There's many counties out there, particularly smaller rural counties, that simply cannot afford it in many cases, putting them in a situation where they have to raise property tax levies, cut services, or find some other creative means to pay the cost of providing defense for indigent defendants. Since 1996, the commission has represented or currently represents more than 1,500 indigent defendants who were charged with and or convicted of murder, kidnapping, sexual assault, manslaughter, child abuse resulting in death or seriously bodily injury, and robbery, and drug distribution in 72 counties, 185 indigent defendants in murder cases in 53 counties, and 13 indigent defendants who were sentenced to death, and one indigent defendant who was executed. While Lancaster and Douglas County can't afford the cost of defending people charged with the most heinous crimes, most of Nebraska's rural counties do not have a public defender with experience defending murder cases, with even fewer having experience defending a death penalty case. If the commission takes a case on, it does not bill the counties for any of its services. I will note that both Douglas and Lancaster counties have used and benefited from the services of the NCPA as well. However, the NCPA must be asked to accept cases. From 1996 to 2003, the commission received general funds. During this period, the counties that used the commission services were required to pay 1/3 of the commission's actual cost of the defense. At that time, 2 of the commission's 6 lawyers' salaries were funded by grant money that was no longer available in 2003. In 2001, the budget session, large growth was projected for the budget for the next biennium due to the construction of the Tecumseh prison and one-time aid to community colleges. Additionally, the general fund minimum reserve was projected to have a $37.1 million shortfall. Because of those issues, the legislature determined the commission could sustain itself with a $2.75 indigent defense fee to be taxed as cost in most cases filed in Nebraska state courts. In 2003, the commission became 100% cash funded. The salaries of the commission's 6 lawyers, administrative assistant, paralegal, and investigator were paid with cash funds. In 2005, the indigent defense fee was increased to $3. The fee has not increased in 18 years or since 2005. The current financial situation of the NCPA is projected to worsen if something is not done and no additional funds are appropriated from the general fund or received from a fee increase. At the end of the fiscal 2021-2022 year, the commission had a $64,000 in its cash fund. In the current 22-23 fiscal year, the commission is projected to be in the red by $20,500. In the fiscal year 23-24, the commission is projected to have a cash balance loss of $935,000. Ultimately, something needs to be done this session, or the commission will have to expended the entirety of its cash reserve. For the last several years, the commission has had more murder cases, including death penalty cases, than it should probably handle, and have been declining appointments, most non-homicide cases. Because the commission was created to defend murder cases, it has always accepted appointments in murder cases despite its heavy caseload, unless it has a conflict of interest. With adequate funding, the commission could fill the attorney vacancy and return to the caseload carried before the vacancy. With the additional funding, the NCPA could hire a seventh lawyer and carry a greater caseload, including some sexual assault cases, and provide even greater property tax relief to the counties that uses its services. Rising operating costs is one factor for the difficulty of keeping the commission funded today. Another item to consider is the fact that court filings have decreased significantly since 2008, therefore impacting the commission's budget and ability to adequately fulfill its mission. It's difficult to quantify this decline, but prior testimony before this committee this year and in previous years reveal it is happening. Part of the reason for this drop in filings is that some proceedings where fees might be charged now take place outside the traditional court setting. COVID in 2020 was also a big disruptor as well. The NCPA now projects that the revenue received from the filing fees will decrease 6% each year for at least the next 3 fiscal years. I know the legislature has looked at this issue several times. Former Senator Moorfield introduced a couple of bills while Senator John Cavanaugh had an interim study on LR 396 that looked at this issue last year. The Appropriations Committee found that possible mechanisms to fund the commission include the indigent defense fee at the present rate at $3 or at a greater rate, general funds contributions from the counties that use the commission services, or the combination of these mechanisms. The commission contacted national criminal defense organizations about grant funds and learned there presently are no grant funds available for offices like the commission. LR 395 did find that with adequate funding, the commission could fill the attorney vacancy and return to the caseload it carried before the vacancy. I believe you all should have handouts on the NCPA from when the committee was heard LB 555 earlier this year. Senator John Cavanaugh also introduced LB 554, which would appropriate $2,100,000 from the general fund to the commission in fiscal year 23-24 and the fiscal year 24-25. It is my understanding, however, that Governor Pillen's budget recommendation encourages the legislature to consider changes to the indigent defense fee as opposed to appropriations from the general fund. If the general funds can't be found, the only path forward that I see to fund the NCPA is to raise fees. My bill does this with a $5 increase to the fee and provides the committee with another path forward to keep the commission funded as is. Per fiscal note, in fiscal year 23-24, the commission predicts the indigent defense fee will generate $1,112,975 in additional revenue. In fiscal year 24-25, the commission predicts the indigent defense fee will generate $1,057,325 in additional revenue. The additional revenue will allow the commission to meet its budget request of $1,757,187 for the fiscal year of 23-24 and $1,848,090 for the fiscal year 24-25. As you see from one of the handouts I gave you, if I would say that if this committee decides to go with the fee route, at the very least, there needs to be at least a $3.55 increase to be able to meet current needs for the current budget. But the commission would be left short one lawyer. Todd Lancaster from the NCPA will follow me with more in-depth information on the cash crunch that the commission faces. Highlight the good work that they do and answer any of your questions. I know that he's brought some documents and other things to explain the need for this increase. He also brings a wealth of knowledge regarding the commission. I urge you to support the good work of the commission by your favorable consideration of LB 767, and I would be happy to try to answer any questions.
Any questions from the committee? Senator Black.
Thank you, Chair Wayne. Senator McKay, thanks for bringing this forward. I'm going to save some of my questions because I did listen to you in the opening for the expert, but I do have two questions for you. LB 554, Senator Cavanaugh's bill. It's our understanding that the governor won't fund that from the general fund. So I guess the question I have for you, and I'm not saying this to be a smart aleck, what would you say the definition of indigent is?
What's the definition of what?
If you're indigent, what does it mean?
Is that you're a defendant that's probably not going to be able to afford a trial attorney and you're going to have to use a public defender?
So isn't that the purpose of why we have the filing fee so low? And why are we depending on them to fix a deficit that obviously we screwed up on? I mean, even if you raise the rates, you're basically saying we're still going to be short $500,000. They clearly need the funds. We're giving raises to judges, which again, I'm not saying they don't deserve those raises. And I think that the vast majority of people, except for maybe the parole board, are underpaid here in Nebraska. And that we do need to have competitive wages. But with that said, we're only talking $2 million is a lot to me, but in our budget, we know it's not huge. Why can we not go back to the governor's office and say, we have LB 554, we need this to be sustainable and part of the budget. We need to take a serious look at this over some of the other silly things we're funding in this budget. Why are we going to tap people that are indigent for more money?
In my opening statement, I stated that the governor approves or likes the filing fee case scenario over the general fund.
But who's the legislative body in Nebraska?
Can I finish?
I know.
Please. No, I'm
Actually,
explaining.
I want to know that. Who's
Okay.
the legislative body, Senator?
We are.
Okay.
But with that being said, if we're able, there's going to be a lot of debate on how this commission's funded. So it doesn't say it's off the table for general funds. It does say that these are the two options that are being brought forward. Senator Cavanaugh and I have both visited with each other extensively on it. We've asked some other options, and they'll be heard behind it and be said in my closing that there are opportunities to either work one or the other bills. In my estimation, in my opinion, we need this funded one way or the other. Where the money comes from, that's yet to be determined, but we need to work on getting this because there are counties going bankrupt with
I agree, but you still have not answered my question. Why have we not gone back to him and asked that question?
Senator Cavanaugh and I have talked this morning. That is a conversation that will probably happen in the first part of next week. We've talked appropriations, and we're trying to work out a system, out of an equation that will benefit all of us. And so it's not off the table. We are going to be talking to Appropriations Committee. We've already mentioned our concern with it. There's a lid out there that on how much they are wanting to, everybody's asking for money. So they're wanting to make sure that the money that's being appropriated out through that committee is what they intended for it. So those conversations are happening with the Appropriation Committee this morning. They will continue. There's going to be a conversation with the governor. So there's still a system to be worked out equation to meet the needs of to cover this fund going forward.
Oh, okay, thank you.
Thank you.
Any other questions from the committee? Thank you. And the first up, we'll have proponents. Welcome back.
Thank you. My name is Todd Lancaster. I'm an agency counsel for the Nebraska Commission on Public Advocacy. I've been with the commission since 2007. Jeff Pickens, chief counsel, couldn't be here today. He had surgery this morning. I'm sure he wishes he was there instead of in a bed. Last March, as we heard Senator DeKay, and I'd like to thank him for bringing this bill today, introduced LR 396, an interim study, and I'm having passed out a report from that study that discusses our financial needs and issues. I'm not going to go through the commission's history. It's in those handouts and what Senator DeKay has already told you. The commission since 1996 has tried murder cases and other serious crime felonies throughout the state. We have tried handled 1,500 cases in 72 counties. We have had 185 defendants in 53 counties that were charged with first-degree murder. We've handled 13 cases in which defendants were sentenced to death. We provide services to the counties at no cost to the counties because we don't charge the counties any money for our services, thus saving them millions of dollars in taxes so they don't have to pay for appointed counsel. The $3 indigent fee, as stated, has not changed since 2005. Case filings since 2008 have declined dramatically. The commission's revenue based on that $3 fee in 2008 was $1.3 million. In 2021, the fee was the amount was less than $7,500. Our present annual revenue is down $550,000 compared to 2008 and 2009. And we predict that filing fee decrease of 6% will occur for the next few years. Since 2014-15, we've had to draw from our cash fund. In 2015, our cash fund was $1.2 million. In 2020-21, it was $15,000. There are two competing bills, as you have heard, and you've heard that Governor Pillen believes that we should be adequately funded through the filing fees. Obviously, senators can debate about which is the most appropriate, but we hope that the members of this legislature and committee believe that we serve a vital purpose and that providing indigent fees for counties or indigent defense for counties saves those counties lots of monies. Counties throughout the state that we've represented people in first-degree murder cases and death penalty cases. So we would ask that you advance LB 767 to the floor, and I'd be happy to answer any questions this body might have.
Any questions? Senator Blood.
Thank you, Chairman Wayne. Why is your preference to move this bill forward as opposed to LB 554?
I would tell the committee that the chief counsel, Jeff Pickens' preference is either of those bills. His concern is that we remain funded.
I concur. I think the work you do is very important. So I want to put that out there just so you know you don't have to sell me on how important you are. But my concern is that it seems that not everybody feels you're that important if they're putting the burden on you to figure out ways to pay for something that we really should provide in the state of Nebraska and should be in our budget. That's where I stand.
And I think Senator DeKay in his statements kind of addressed this. We at one point were funded by the budget, general funds. And when there was a shortfall, the body decided we could be funded through this indigent fee. And that worked for a while, but then the filings went down so dramatically.
Sure.
And with that, our revenue has gone down dramatically.
How long ago was that? I was trying to find that in the report.
Pardon me?
How long ago was that? I was trying to find that in the report.
Since 2003 was when we switched from general funds and grants. There were some federal grants that then were discontinued.
Mm-hmm.
And so in 2003 is when we switched to being funded solely by the indigent defense fee. So that was the only way we could get any money. And that's, as to this day, the only way we get funding unless this body gives us supplemental funding, which happened in the last 2 years because of our shortfall.
So have you been trying for a while to bring attention to this concern?
Yes. We brought this to I believe it was either this body or the Revenue Commission probably 6 years ago. And so at that point, there was a move to take, I think, $250,000 from our cash fund. And we came and testified that we needed that because our funding was going down so much. And we were told not to come in and ask for more money until we used up our cash fund.
Well, 6 years ago, we used to have death by fiscal note because we had money. Now we have money and it seems like it's a free-for-all, but we're missing opportunities to fund things that we really need to fund. So I appreciate you giving me a little history on that because I was waiting for you to actually tell me that. So thank you very much.
Certainly.
Any other questions from the committee? Seeing none, thank you for being here.
Thank you very much.
Next pro corner.
Good afternoon, Chairman Wayne and members of the Judiciary Committee. For the record, my name is Elaine Menzel. That's ELAINE-MENZEL. Here today on behalf of the Nebraska Association of County Officials in support of LB 767. And as was testified by Senator DeKay very aptly, this is a public advocacy commission is very valuable to providing indigent defense services. It assists counties with respect to providing property tax relief because counties are responsible through the U.S. Constitution, which then comes down to the state, and then the counties are required to provide that indigent defense. And so within the state statute, it talks about within your legislative intent, why in part the Public Advocacy Commission was developed. I am providing you the same information essentially that I provided to you when Senator Cavanaugh introduced LB 555 related to Public Advocacy Commission and cautioned that we hoped that you would continue to fund the commission and keep them for the purposes for which they were initially developed. I do want to extend my appreciation to both Senator DeKay and Senator Cavanaugh for their keeping this issue to the forefront. At the legislation, LB 554 was introduced in front of appropriations last week. One of the questions that I was asked while I testified on that was whether we preferred it to be cash funded or general funded. And I said, we don't care, rather that we just want it to be funded. And frankly, I would like for both to be occurring so that their services are able to be at least at a bare minimum sustained, but possibly enhanced. With that said, I think perhaps a combination of the two proposals could be used so that rather than be competing, that they could be used in combination. With that, I'll ask that you perhaps, just one additional comment. Senator Blood, you had asked whether this is an issue that's been brought to the Judiciary Committee before or legislators before, and it has been through the years, and it has been something that we have continued to support the commission's work. So with that, I'll answer any questions if I'm able to.
Any questions? I have a really dumb question. Are you guys an agency?
We're a nonprofit agency or association, excuse me.
But we don't fund you directly, though. How does it go?
You do not fund us directly, or you're correct. The counties do pay membership dues in part. We also offer various other programs and services that we receive funds through.
So it was created at County Revenue Assistance Act, provide property.
Oh, I'm sorry. Are you asking about the Public Advocacy
sorry.
Commission
Yeah,
versus
yeah,
our
I'm
association?
sorry.
I apologize.
No, that's me. I asked a bad question. So I should ask the other person. Sorry.
the Public Advocacy Commission is funded through cash funds, my best understanding. Previously, it had been funded through general funds and a portion of counties being reimbursed.
Do you know this answer? And if not, I'll have to ask them afterwards. Do you know if it's directly given to them or do they go through an agency? To my understanding, we can't give directly to things. We have to go through an agency. You don't know?
I better stop in trying to attempt to help you through.
No problem.
Sorry.
Any questions? None. Thank you for being here.
Thank you.
Next proponent.
Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Mike Guinan, Mikeguinan, and I am the Criminal Bureau Chief from the Nebraska Attorney General's Office. I appear before you today on behalf of Attorney General Mike Hildress and the Nebraska Attorney General's Office in support of 767. We support LB 767 because our system of justice is benefited by having capable attorneys prosecuting and defending major crimes like murder, and we have an acute need for criminal attorney resources in greater Nebraska. Rural Nebraska is losing attorneys. It's been my experience that rural counties are not just short prosecutors and defense attorneys, they are short attorneys in general, with experienced attorneys dying, retiring, and moving on, and too few attorneys moving in to replace them. This leaves a wide range of legal work, trust and estates, business planning, family law, tax work, criminal defense work, and so on, spread over fewer and fewer attorneys. When it comes to handling major crime cases such as murder, it is clear that the problem is especially acute. Murder cases, for instance, require significant effort and expertise, months, if not years of preparation, reviewing stacks of records, gigabytes or possibly terabytes of reports and discovery, coordination of numerous lay witnesses, involvement of expert witnesses from across the state or maybe across the nation, knowledge of the relevant science, case law, suppression issues, overall motions practice, and so on, and the ethical obligations to represent your client zealously and competently, all combined to demand a huge dedication of time, effort, and expertise. There are many smart, talented, and accomplished attorneys across the rural part of the state that could handle these cases. So many of them, though, do not have the capacity to take on such cases. The Nebraska Commission on Public Advocacy plays a vital role in this state's criminal justice system, filling this void. These major cases also involve a large expense to the counties in which they occur prior to trial, for trial itself, and then afterwards on appeal, especially in cases involving indigent defendants. You never want to try a case twice, and is no truer than in a murder case, given the time, effort, and expertise and expense. With the commission, you have a group of attorneys with the expertise and experience to handle these cases correctly, avoiding the numerous pitfalls which can lead to significant time, effort, and expense of trying the case again. From the number of cases we handle with the commission, I'm aware that they are stretched very thin in terms of personnel. For example, just the other day, we received our fourth call from a county attorney seeking either guidance or assistance in a homicide case, all outside of the Lincoln or Omaha metro area since the beginning of the year. I presume the commission may have received the same calls on most or all of these cases. These are the types of cases in the areas of the state that the commission cannot simply decline to take. While the Attorney General takes no specific position on the source of funds.
Supreme Court will cut you off.
Sure.
Especially because it's Friday. Any questions? So one question, do you trial most of them, not you? Does your office come in and prosecute most of these murders in rural or do local?
We handle probably the majority of the cases out of state, yes. Not all.
I'm about to put you on the spot for an ethical question. Do you think if this was tucked underneath the judicial branch, there's an ethical problem with judges appointing this commission or an attorney from the commission and being paid out of the general budget? I'm just trying to think if there's because right now the problem is they're in their own little thing, and but if this was part of an overall branch of government, then they'll get general funds.
I don't know how to answer that, Senator.
But you don't, it's not, I don't know. Don't worry about it. I was just asking Because I'm trying to figure out if they control the budget, they appoint it, and then there was an appeal from it, how would that, to the Supreme Court, would they be?
Would the commission handle their own appeals? Is that
Yes.
what you're asking?
Yeah.
They do.
They do.
Yes.
That might be a problem. Okay, I'm trying to think through this. Any questions? All right, I'm just trying to get the general funds. I'm sorry. Go ahead. Have a good day. Sorry.
Yeah,
I'm getting
thank
late
you.
now. Next proponent. Welcome.
Thank you, Mr. Chairman, members of the committee. Jason Graham, JASON-GRAMS. I'm the president of the Nebraska State Bar Association, and I make this statement in support of LB 767. Just outcomes in criminal cases require capable counsel for both the prosecution and the defense. The Nebraska Commission on Public Advocacy was created in 1995 to provide legal representation to indigent defendants charged with first-degree murder and serious violent or drug-related felonies. The commission was created in part as a way to provide property tax relief and to protect smaller counties from bankruptcy. Prior to the establishment of the commission, a small county could go broke covering legal fees associated with a single capital case. The commission is currently understaffed, and without an increase, the commission will have to reduce services available, thereby increasing costs to counties. These are complicated cases, and the stakes are very high. I'd say some of the most complicated cases. Having a commission on public advocacy also helps ensure that the lawyers providing representation in these cases are well-trained and experienced. If quality representation is not provided on the front end, then counties can expect a claim of ineffective assistance of counsel and incur additional fees defending that. As you can see from the maps that we disseminated, there are 12 counties in Nebraska without access to a single attorney today, and 18 others with 3 or fewer attorneys. We projected in the next 5 years, if the number of lawyers reaching retirement age are not replaced, those numbers will increase to 18 counties with no lawyers and 32 with 3 or fewer. And I'd mentioned that a lot of them don't take criminal defense appointments. Simply put, there are some areas of the state where there are no lawyers available to competently handle these types of cases. The commission is currently funded from court filing fees. Over the years, the commission's been asked to take on additional functions without additional funding. Court filings across the board have been decreasing over the past several decades for a variety of reasons, and this trend seems to be continuing. To stabilize funding for this important state agency, the filing fee must be increased. And I would just say, since I have a little bit of time left, that the Bar Association supports this and the other bill. And that's our position in conversations. We didn't vote on this, but I can tell you that it's also the position of every member of the Executive Council of the State Bar that I talk to, that the funding for this agency should come out of general funds and not fees to keep it at a level and allow planning by this important agency. If there are no questions, I'd ask that both bills be advanced.
Thank you. Any questions? Seeing none, thank you for being here.
Thank you.
Next proponent. We'll turn to opponents. First opponent.
Good afternoon, members of the committee. My name is Spike Eichholt, SPIKEEICKHOLT. I'm appearing on behalf of the ACLU of Nebraska in opposition to LB 767. I did visit with Senator DeKay on a number of occasions and explain our opposition. We have no opposition whatsoever to the Commission on Public Advocacy. They do serve an important purpose. They are a valued agency for the state, particularly for the rural parts of the state. The attorneys in that office are some of the best in the state that practice criminal defense at the trial and appellate level. The issue that this bill presents to us that we have opposition to is how it is paid for. As Senator Wayne alluded to, we don't have a court fee system to pay for judges. You heard earlier today how judges deserve a pay raise from general funds. The Attorney General is here testifying in support of this bill. Their office is paid for by general funds. Indigent defense, quality defense should be paid by the state similarly as general funds. It's an obligation the state has to provide for this cost, and particularly for the smaller counties. Attached to my testimony, I have given some examples from my own failing law practice of how these court fees work. They are user fees. In other words, you pay it every time you go to court, whether you're there for a criminal case, whether you're there for a civil case, whatever. And I've given some examples of how it's broke down. If you look at some of the examples I got there, there's an indigent defense fee of $3 that's taxed on every case. You want to divorce your abusive spouse, you pay a bunch of court costs, and included in there is indigent defense fee. That's who it's going to be increased upon. You get stopped for a traffic ticket, and if you're a particular part of the state, in a particular part of the community that's over-policed and overcharged and over-prosecuted, you're going to get that tax. It's a tax on people who go through the system. That's the only way to look at it. That's the accurate way to depict it. And frankly, as a member of the Bar Association, I can say this because I'm sure they'll take my money next year when I'm asked to join. I'm disappointed that the Bar Association is here supporting increasing court fees. Courts should be open, just like the legislature's open. I don't pay a fee to testify on bills. That's my right. Maybe I should. It costs staff time, of course, to do, and there are people here that have to work for it. So of course it has a cost, but that's an obligation that the legislature provides for the community. Similarly, if I want to use the court system for redress, it should be open, affordable, and the association, the professional association, should not lobby and advocate for increasing fees. We are opposed to that. We did support Senator Cavanaugh's LB 554. We are at a time in our state's budget where we have ample reserves, and really what the state, or what the Commission on Public Advocacy needs here is a modest amount of money. We would encourage the committee to not advance this bill and instead ask that the legislature appropriate general funds to cover the costs for the Commission on Public Advocacy.
Any questions from the committee? Seeing none, thank you for being here. Next opponent. Welcome.
Thank you. Chairman Wayne, members of the Judiciary Committee, my name is Robert Brandt, ROBERT, I'm here on behalf of the Nebraska Collectors Association to register our opposition to LB 767 and make a little bit of history, being on the same side of a bill as the ACLU. This bill will increase the filing fee for court actions, increasing the indigent defense fund by $5. The Nebraska Collectors Association membership, we make up some of the largest users of the civil county courts in the state where most of our cases are filed. This $5 increase would represent about a 10% increase in the overall filing fee, which is currently $49. And so the purpose of that increase is to fund the indigent defense. It's the indigent defense fee, which would fund this program, which we do not oppose in any way, and we support it. We just oppose the funding mechanism. So like the ACLU, we would ask that this committee consider other funding sources from the general fund, instead of increasing court fees. The judicial system is not and never has been meant to be a user fee-based system. Increasing the fees limits access to the courts and puts a burden on the average citizen as well as those who can least afford it. Court costs are often taxed to the consumer in our cases, and so those fees are putting burdens on citizens who are already struggling. That burden extends from the consumer all the way through to the Main Street businesses who will have to pay more initially. And that comes down to a business decision where they have to consider the filing fee when they are deciding whether to file a case or not. So we've heard a lot today about the decrease in case filings. And so this increase might be counterproductive in the sense that these Main Street businesses might file less cases, and then they're going to lose some funding that way anyway. This proposed increase also comes at a time, as has been mentioned, when the state has more money than they've ever had before, and they can appropriate that money through the general fund. So I would ask this committee oppose LB 767 because of its funding mechanism.
Any questions? Seeing none, thank you for being here.
Thank you.
Next opponent. Anybody testify in a neutral capacity? As Senator DeKay comes to close, we have 5 letters for the record, 4 in support and 1 in the neutral capacity.
When it comes to fee increases, I am willing to work with the committee on that, however we get to that point. I will reiterate that keeping the NCPA funded will help with property tax relief. It is ultimately up to this committee and legislature to decide on the funding mechanism that they want to pursue. There are many combinations to get this funded, and Senator Cavanaugh and I agree that this is needed to be funded in some form, and we are willing to work to accomplish it. With that, we thank you for your time. If you have any questions, I'll try to answer them.
Any questions from the committee? Seeing none, thank you for being here.
Thank you.
And that'll close the hearing on LB 767 and open the hearing on LB 156. Senator DeBoer.
Hello, Chair Wayne and members of the Judiciary Committee. My name is Wendy DeBoer, W-E-N-D-Y-D-E-B-O-E-R, and I represent the 10th Legislative District in Northwest Omaha. I'm here today to introduce LB 156, which increases the caseload cap for the Office of Public Guardian, which I'll refer to as OPG. Currently, the caseload is capped at 20 public wards per member of the OPG multidisciplinary team. LB 156 would modestly increase that caseload cap to 22. When the OPG was originally established in 2014, the caseload cap was 40 per associate guardian. In 2016, the cap was reduced to the average of 20 per each full-time member of the multidisciplinary team. When our Office of Public Guardian reaches its current cap, any new referrals are put on a wait list. In 2022, that wait list had 96 individuals on it. But I'm told that judges know how long that wait list is and don't even put many of the folks on the list that they know need to be on the list because it's just so pointless to get on such a long list. So the number of folks that need guardians is likely much longer. Hospitals or physicians are by far the largest referral source for the Office of Public Guardian. In many cases, individuals on the wait list linger in a hospital after being medically ready for discharge while waiting for a guardian to be appointed. Because a legal guardian is necessary to access a payer source, like Medicaid, and to consent to treatment decisions, like transfer to post-acute facilities. Post-acute facilities generally will not accept a patient without a payer source or a legal guardian to make medical decisions. Patients remain in the hospital long after their need for acute care has subsided, and that is rarely what's best. It's never what's best for patients, and it creates all kinds of challenges for our hospital system because we have people who are in hospital beds who do not need to be in hospital beds for hundreds of days longer than they need to be. I'm not exaggerating by that. Hundreds and hundreds of days more than they need to be. So this creates a capacity strain on our hospitals for patients who are sitting there waiting just for a guardian. They're at the highest level of care and they don't need to be. Just waiting to be transferred out of the hospital because there simply isn't room for them on our guardianship program. We need public guardians to help those who cannot help themselves. So lack of guardians affects our hospital capacity, the cost of healthcare, but much more importantly to me, a lack of guardians leads to worse outcomes for patients, a worse quality of life. You can imagine living in a hospital bed versus living in a care facility. So my goal is to find solutions that support the capacity of the OPG to enhance outcomes for folks who shouldn't have to live out their lives in a hospital bed simply because there's no one to do their paperwork. This bill and the one that's next are a number of different solutions that I've proposed to get folks off that wait list and out of the hospital beds that they don't need to be in. But I look forward to working with you and other colleagues to enhance the capacity of OPG to meet the needs that exist across our state. Thank you.
Any questions from the committee? Hearing none, thank you.
Good afternoon, Chairman Wayne, members of the committee. My name is Laura Betzold, Laura-Betzold. I'm here representing Nebraska Medicine. I provided written testimony, but I just want to highlight a handful of things. First, as a hospital, we are required to treat all who come to us, but the next level of care, the post-acute care facilities, are not required to take everyone who needs them. And so that creates what you've heard already about, which is this set of patients who are in our hospital who don't need our level of care, but cannot move on to the next level of care. Many of these patients require a guardian because they can't make decisions for themselves. They can't sign documents regarding their healthcare treatments. They can't complete paperwork for benefits. They can't approve the type or location of care after hospitalization. We do everything we can and try to use less restrictive alternatives to guardianship, but many of those are not options for these patients. They can't use a surrogacy act because we aren't able to find any family or friends who qualify as decision makers for them under the Surrogacy Act. We can't use POA or have them sign something at the time that they come into us, like some people can sign a consent to treat because they obviously don't have capacity. And oftentimes we can't use limited guardianships because many financial institutions and banks only recognize full guardianship. When a guardian is needed, we search everywhere for family or friends. And if they are unable or unwilling to assume this role, then we have to turn to the state and the court system to appoint a guardian through the Office of Public Guardian. What this means for our patients is a very long hospital stay that's not needed. They stay anywhere from 137 days to well over a year waiting for a public guardian. This is terrible for their health. It's expensive to the health system, and it means that a hospital like ours can't serve patients who need to transfer from other hospitals for our level of care. We're looking for all solutions. Last year, we advocated for successfully more money for OPG for more public guardians, but the result has not helped. We have the same number. We currently have 7 patients who've been in our hospital and remain in our hospital who don't need our care, but can't move on because they're on the wait list. While we recognize this would increase the caseload for public guardians, we are not set up to handle these patients, and their health just gets worse while they're with us. So we're looking for any other solution we can. This is one option. There's another bill. And we're also open to discussing other alternatives.
Thank you for your testimony. So the 7 patients, any questions? Can't Nebraska Nebraska Legal Aid, can't they file a petition on behalf of those 7?
Yeah, so those 7, we have more than 7 patients who are waiting. And we actually, over last year, we had about 950 avoidable days patients were in the hospital who needed to get out. And we do have a medical legal partnership with Legal Aid, and they actually are the ones who handle petitioning, but they petition the court for a public guardian to be assigned to these patients. And they, like these 7, for example, they've gone to court. The court has agreed that they need a public guardian, but then they're on the wait list because the Office of Public Guardian responds to the court that they don't have capacity. And because they have X number of public guardians, they each can only handle by statute 20 cases. And so they can't take them.
Can a hospital become a public guardian? Become a guardian of a
Actually, no, there's a statute that prohibits caregiver, people who are responsible for the care, from acting as a guardian for these individuals, for anyone in their care.
Okay. There were questions. I have plenty of them. That's okay. Thank you. Any other questions? Seeing none, thank you for being here. Next, proponent.
Chairman Wayne and members of the Judiciary Committee, my name is Margaret Weppel, M-A-R-G-A-R-E-T-W-O-E-P-P-E-L. I'm the Vice President of Quality, Data, and Workforce with the Nebraska Hospital Association. And thank you, Senator DeBoer, for introducing this bill. After hearing numerous anecdotal stories about the difficulties transferring patients out of hospitals and into post-acute settings, the Nebraska Hospital Association began collecting monthly data from our member hospitals since last fall. According to this data, statewide, 290 patients have been waiting longer than 7 days for placement in a post-acute setting. And this is one snapshot a month over month. In addition to those 290 patients waiting longer than 7 days, 10 to 20 patients have been waiting longer than 6 months. Lack of guardianship is one of the top 10 barriers to discharge from our hospitals and is attributed to those who have the longest days or those who've been waiting over 6 months. As you can imagine, these patients, or citizens of Nebraska, are not happy waiting in limbo at a hospital for weeks or months to move into an appropriate post-acute care setting. In the summer of 2022, the NHA launched a Transitions of Care Council to monitor and provide solutions to this issue. Members of the council include hospitals, post-acute, and the Nebraska Office of Public Guardian. During these meetings, we have explored the reasons for prolonged delays, and the Office of Public Guardian has reported that they are experiencing staffing and resources shortages. The Transitions of Care Council has discussed these challenges at length and are proponents of this bill as one piece of the Transitions of Care solution. We support increasing the average ratio from 20 to 22. During our Transitions of Care Council meetings, we heard from neighboring states and their ratio goes up to 40. A modest increase to the ratio of an average of 22 to 1 for Nebraska is a conservative but proactive step towards getting patients into the appropriate care setting. In 2022, the Office of Guardian report stated they had a waiting list of 96 Nebraskans. If each of the 17 guardians in that report took 2 additional Nebraskans, we would immediately reduce the wait list by over 1/3. Nebraska hospitals do understand that guardianship cases are complex and ratios must be carefully considered, which is why we support this conservative step of increasing the ratio by 2.
Thank you.
Thank you.
Any questions from the committee? No, I wrote down some questions and I was just making sure I had. No, you're good. Sheena, thank you for being
Thank
here.
you.
Welcome.
Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Dr. Lisa Vail. I am L-I-S-A-V-A-I-L. I'm the System Vice President of Patient Care Services and Chief Nursing Officer for Bryan Health, a locally owned and governed Nebraska hospital comprising of 6 medical centers. I've been a registered nurse for over 40 years. I come to you today on behalf of Bryan Health System and the patients we care for in support of LB 156. At any given time, there are approximately 50 patients effectively stuck in one of the Bryan Health hospitals due to a multiple of complexities. They no longer have medical necessity for acute care services, but require a level of care beyond what they could provide for themselves. This population of patients need post-acute placement in a long-term acute care hospital or in a rehab, assisted living, skilled nursing, or long-term care facility. All of these facilities require a payer source and a decision maker to review a patient's case for placement. When a patient is determined to be non-decisional and does not have a family member or friend who can serve as their decision maker, one must be assigned by the Office of Public Guardian. It is not uncommon for patients to wait 6 months or longer to be assigned a guardian. We currently have one patient with a length of stay over 480 days. Their first barrier to discharge was guardianship, of which they waited 388 days, submitting the application every 90 days as per the OPG procedure. Now they face another barrier of securing a payer source, which can be another months-long process. Once both of these steps are complete, a facility will review the case for placement, as none of these steps can concur simultaneously. This bill increases the caseload for public guardians from 20 to 22, as we've already heard. It will allow the OPG to care for 32 additional wards with their current staff of 16. LB 156 will not fix the complex case placement challenges in our state. This bill is a piece of the patchwork of solutions that are before the legislature this session. Earlier in the session, testimony was heard by the Health and Human Services Committee on LB 353, 227, and 517. Today, you are hearing testimony on LB 156 and 157. It takes approaching this issue from a variety of angles to completely solve the crisis. LB 156 will create desperately needed capacity in the Office of Public Guardian, broadening their bandwidth to provide this important public service for patients across our state, improving the process for proper post-acute placement. I'm grateful for the opportunity you've given me this afternoon to share with you a glimpse of the challenges our Nebraska hospitals and the patients, friends, and neighbors we mutually serve face. As you hear from myself and others today, I ask that you be moved to take action in support of 156. Thank you for your time, and I'd be happy to answer any questions.
Thank you. Any questions? Seeing none, thank you for being here. Next, proponent. All right. Moving to opponents. Next, opponent. The whole sing songs. Like the transcribers have to hate me. They have to hate me. Welcome. Thank you for your patience for this long Friday.
Oh, well, thank you for waiting me while I juggle things. So my name is Michelle Chafee, Michelle, and I'm the Director of the Office of Public Guardian. Good afternoon on Friday to the Judiciary and to Chairman Wayne. I'm here in opposition to LB 156. The caseload capacity for the OPG was adjusted by the legislature in 2016. Data collected over the first year of the OPG implementation demonstrated that associate public guardians served individuals with high needs, including severe and pervasive mental illness. Full guardianships were 99% of the appointments. The associate public guardians serving the Office of Public Guardian wards averaged 2.5 hours per week per ward. So the total caseload capacity at that time for the APG was 40. And despite best practices and the national standard of being 20 cases per caseload, it was identified that yes, they needed to reduce it to 20, because 20 would still be a 50-hour work week for my associate public guardians, which is what it continues to be. In addition, the rest, it was a 1.5 hours for the disciplinary team. So on top of that, so every ward takes 4 hours per week per ward. I provided you the 2022 OPG annual report, and it just to show you that it does identify that 2.5 hours per week per ward is still what we're looking at in regards to our responsibilities. So If you added 2 cases for the 28 OPGs, that would result in 40 additional wards across the OPG with 160 hours of additional staff per week. We just don't have that ability. That means we'd have to pay overtime, which, as you'll see in the fiscal note, ends up being quite a bit of money. The most important thing that I want to challenge, though, is that this is really an issue that would cause real concerns for the wards that we serve. And if you add 2 more to an already overburdened system with no additional consideration, then you're going to end up with not only continued overturn like I've had in the last year. We've lost five associate public guardians who the workload has just been too much. So I am concerned about that. I would also point out that the statistics of the Nebraska Hospital Association, and
Thank you. Any questions from the committee? Senator Holcroft, followed by Senator Blood.
Thank you, Chairman Wayne. Sorry, I never even knew we had an Office of Public Guardians. So you fall under probation, is that right?
the Supreme Court.
The Supreme Court.
Uh-huh.
And what is do you have an authorized strength? Is that, that restricts you from hiring more people? Or is it just that you can't hire more people? I mean, you can't find the people.
This year, it has a lot to do with the turnover, and yes, we've tried to hire more people. I hired 3 additional people and had them quit within 6 to 8 weeks. I then hired 2 more, and they quit within the first 3 months. I mean, the job is really, really tough. And one of the things I want to point out is that part of the issue with the Hospital Association, which you'll see on their statistics, is that it's the lack of behavioral health or places for people to get out of the hospital to go. And so when you have severely mentally ill people, there are many, many locations in the state that will not take them, even with a guardian. The person that they identified that was in the hospital for a number of days, and even after they had a guardian, is because there's nowhere place that will take them. And the person has immigration issues, and so they did not qualify initially until we could find the immigration information. So it takes an incredible amount of work in order to try and meet the needs of people who absolutely have no one in the world except and try to take care of their needs.
So what are the qualifications to be a public?
To be a public guardian, you need to have a bachelor's degree and then have a history of case management, so dealing with people. We have ones that have dealt with developmental disabilities, mental health issues. We also have people who have been involved with mental health issues or social work. And so those are the types of people that end up working for us.
Okay, I saw a number here. Someone said there were 17 public guardians. Was that?
There are currently serving, there are 17. We got 3 additional this last year, so we have 20.
Okay, and are you dispersed? I mean.
Yeah, we have people in Scottsbluff, North Platte, Kearney, Hastings, Norfolk, and then we have people who are in Lincoln who serve the Milford York area and also the Wapoo area. And then we have a number in Omaha.
Okay, thank you.
Senator Blood.
Thank you, Chairman Wayne. Thank you for coming out. I am familiar with the work you do, and I thank you for it. I think it's very important work, especially when we're talking about people towards the end of their lives. I think we in Nebraska and other states have taken away a lot of dignity that these people deserve, and so I'm glad there are people like you.
Thank you.
But with that said, I'm concerned because you're in opposition, but I'm pretty sure that our first proponent sits on your advisory board. Is that true?
Mm-hmm.
Why do you think that there's a difference of opinion?
Well, it's just massive. So let's start with First of all, I am totally I understand the problems with the beds. I actually have been a guest to the TOC. But I do not believe that guardianship is the answer for of getting rid of the bed problem. So let's separate out the numbers in the beds of the 900. And if you look at the 7 that they identified, of our wait list, we're able to take 9 people off our wait list in January. 7 of those were from hospitals. So we are, in fact, doing a lot in regards to that. And when you look at the data from last year, across the hospitals, there were 51 individuals who were nominated for our care that were incapacitated and in the hospitals. And so 51 of that 900. And yet we provided, when we do take on guardianships for people, we're willing to do that. We're very supportive of doing that. What we're not supportive of is having 22 people without any increase in, with having no increase in associate public guardians. If they want to increase 2 associate public guardians and for us to take care of those 40 people, I would be glad to do that, but I can't take those 40 people within my 20 associate public guardians right now. Not when they're already working 50 hours a week.
So if I hear you correctly, your issue isn't that you don't think that there's room for improvement, but that you don't see improvement as being increasing the workload, but would be to increase the experts.
Absolutely. Yeah, that's the main issue, is that if we were able to have additional, we were not able to, we have had a wait list for 4 years. And last year was the first time that we had any funding that added people to our services. And so what happens is we are not right-sizing what is really happening in the geographic areas and data in Nebraska. I have 100 people that are nominated to to our Office of Public Guardian every year. I have 25 people that either die or are terminated their guardianships. That means I have 75 that will always be on my waiting list because I have a need for 100 every year. I need 5 public guardians every single year in order to deal with the 100 per year that we get nominated for.
So that's probably one of the reasons that you have a hospital administrator, I'm guessing, on your advisory board, because you know that because of mental health and because baby boomers are aging out, that it's going to continue to increase. Why is the state not giving you what you need? We're putting money into lakes and canals and.
Well, this last year, and thanks to, again, collaboration with the Nebraska Hospital Association and the hospitals and seeing that we needed, they identified and Senator Coulterman brought a bill for $500,000.
Yeah, I remember that.
Okay.
Yeah.
And so that was the first time in 7 years that we had been given any additional funds. And actually, those funds didn't come from general funds. They ended up coming from the Supreme Court who gave those funds. That's what I want to make a point of, is the answer is not having the Office of Public Guardian have more people with less resources. If you would look at our annual report, you'll see that the people that we deal with are some of the most needy people that you would ever come across in the state. And we served 305 people last year. If you look on, I think it's dealing with the type of people we have, they had 1,000 different conditions, those 300 people. They were either had Alzheimer's or mental illness or physical illness, so all of those things, developmental disabilities. We have a lot of people who are coming out of the foster care system, and at 19 and 20, they're being put into our system. Well, we will have them for the rest of their life. So I'm just saying, I'm in opposition to what this bill is asking of the Office of Public Guardian, not in opposition to the hospitals or their needs. I understand.
Or in opposition of bringing on more staff to cover these things.
Right. If you could bring me more staff, I'd be glad to serve whoever you guys identify as the conditions in which I should. Sorry.
Any questions from the Senator McKinney?
How short-staffed are you? What's the number?
Well,
I can answer that. I can't get anybody. Yeah, never mind.
right, okay, right now, I've really struggled this last year because I've been 5 short since June. And then I hire and people leave. And I had somebody leave last week and I had somebody leave in January, even though I hired 3 in January. I was so excited. We were getting so close. But I hope that the funds that have been identified by the Supreme Court to help in staffing, as far as what's paid, will be helpful to that. And I also hope that the $700,000 that's been requested through appropriations, thanks to Senator DeBoer, will be considered. So, okay, those 2 things. To your question. In November, when the Office of Public Guardian's data is collected, I had 90-some people on my wait list. We've been able to get down to 43 people on our wait list and 20 that are still pending. So they're within the process of application. So we have about 63. Of those, 29 are from hospitals. But as I said, recently we're able to take 9 off of our wait list, and 7 of those were from hospitals. We also have just recently, thanks to work by the probate section of the ABA, the Nebraska Bar Association, have stepped up and offered their services to take some of our people from us. So,
how short-staffed are you?
in order to take care of these 63 people, I would need to have 3 more public guardians.
Okay, and a follow-up. I know you mentioned that people need case management experience and things like that. And I know jobs say a lot of things in job descriptions that they actually train you for anyway. So do you really need case management experience, or could you train people up?
We're always willing to train people up, but the problem is that if you don't have the case management, you can't get them, you don't know how to do the Medicaid, the Social Security. We train you how to do that. We do teach them, but people, when there's no place to put people and you're getting calls from 8 in the morning till 5 at night because somebody is mentally ill and out on the street, like at Christmas, you'll see on the first page of my letter, I had 8 people in my guardian that we were guardians for that were homeless, and it was 31 degrees below zero.
So on average, how long would it take you to train somebody up?
We provide a really good, like, you don't have any cases the first 6 weeks to 3. After that, you get 4 cases. So we just start
So you're not throwing people to the wolves?
Right, we're not, because we lost so many people. And so now it's like, okay, even though we have this wait list, we cannot continue to bleed staff.
Also, looking at your team and looking at the advisory team, where's the diversity?
Well, we had, until we lost, we had 3 African-American staff members, until we lost 2 staff members who left. We have a Hispanic, so 4 of the 17 that we had. So we had some diversity, but we're always open. I mean, I was sorry to see.
Why are they the ones leaving?
Well, I think it was finances, it was that you can make a lot more money doing things with a lot less stress because of what our salaries are. So it's just, and then you want to celebrate for that, they got the experience and they moved on and,
Thank
so.
you. Thank you.
Yep.
Any other questions? Seeing none, thank you for being here. Next opponent. Seeing none, testifying in neutral capacity. Welcome.
Good late afternoon, Chair Wayne, members of the committee. Tim Haruza, last name spelled H-R-U-Z-A, appearing today on behalf of the Nebraska State Bar Association in a neutral capacity on LB 156. I'll keep my comments brief. When this bill was first introduced, we had a strong knee-jerk reaction to be opposed to it. There was tons of discussion, and I think there are several attorneys that have serious concerns about increasing a caseload ratio. The one thing I do want to stress in my remarks generally about these types of cases is they're extremely intense. These are the highest level folks who need a great deal of attention and who require a lot of time from the individuals who serve as a guardian or conservator, and the public guardian's ability to handle those cases is stretched very thin. We do very strongly support Senator DeBoer's bill 761 to provide more resources. I really do think this is one of those resource issues. There's a long history of how the guardianship issue has developed in Nebraska, and from the legal perspective and how attorneys serve in these roles. I think the last comments from the testifier before me from Ms. Chafee really do highlight the intensity of the cases, the stress that is involved, and the fact that we probably need more people handling these cases rather than more cases being handled by the same amount of people. With that, thank you very much, and I'm happy to answer any questions you might have.
Any questions from the committee? Seeing none, thank you for being here. Any other people testifying in your capacity? Seeing none, as Senator DeBoer comes up to close, we have 1 letter of support and 0 letters of neutral, 0 letters of opposition. Senator DeBoer, close.
Thank you, Senator Wayne. Thank you all for being here on a Friday afternoon. I wanted to start by saying that the issues with the wait list are definitely not because of the Office of Public Guardian. The Office of Public Guardian is doing amazing, hard, amazing work. I know I said amazing twice. They need to be fully funded. No question, end of conversation, they need to be fully funded. That's why I brought a bill to appropriations this year to add more public guardians. The reasoning for bringing this bill, well, at first I thought maybe it would be modest when we talked to him. No, it wasn't. In part is to demonstrate that we cannot find our way out of this problem by just asking more from an already overworked group of people doing a very stressful job. It doesn't seem like this is the way to get to where we need to go. We're going to have to find another way. So I would ask that the committee hold this bill. Probably should have said that at the beginning. Because this isn't the answer I don't think we're discovering. This isn't the silver bullet. But here's the issue. This is a legal problem. There is a legal cause that folks cannot get to the right facility for them. We are the ones who are responsible for the fact that folks can't get to the right facility, the right treatment that they need. It's not the hospital's fault. It's not the OPG's fault. It's our fault. We have legal barriers, which are good and should be there in place to say you have to have a guardian if you're not capable of making decisions for yourself. Those are laws we put into place. It's not because the hospital's done it. We put those laws into place that suggest this is how folks who don't have the ability to make decisions for themselves get their decisions made. And because of that, we put the mechanism in place to get that done, which is the Office of Public Guardian, because these are people who don't have anyone. Could be me. I'm not married. I don't have any kids. Could be me someday. that doesn't have anybody there to do this job for them. And they're lying in a hospital bed without anyone to take care of them. If this isn't what government is for, I don't know what government's for. Helping these folks to get to the right level of care, to deal with those legal issues that we created the roadblocks for good policy reasons, but we've created them. And now they're in a situation where they cannot get to where they need to go because of us. That's something that we need to fund. We need to fund, we need to strategize, we need to put things together. It's not the hospital's fault. The Office of Public Guardian is doing their very best. That's the problem. That's the problem we're looking for solutions to today. I'll answer any questions.
Any questions from the committee? Seeing none, thank you for being here, and that closes the hearing on LB 156. And now we'll open the hearing on 157.
Good afternoon, Chair Wayne and members of the Judiciary Committee. My name is Wendy DeBoer, W-E-N-D-Y-D-E-B-O-E-R. I represent the 10th Legislative District in Northwest Omaha. I'm here today to introduce LB 157, which allows for the appointment of a temporary guardian for the purpose of assisting a person in applying for government benefits or private benefits. The bill allows, but does not require, the OPG to serve as the temporary guardian for this limited purpose, and allows the temporary appointment. So it allows the OPG to serve as temporary guardian for this limited purpose. And we are envisioning an amendment to this bill, which would allow for the temporary appointment for outside counsel, for lawyers to act in this capacity. Under the green copy of the bill, the temporary appointment would go within the existing OPG caseload. We've just had a hearing on why that would be problematic. We thought that perhaps doing that for a temporary position might be workable. I understand that it would be difficult. LB 157 is targeted to specifically address one of the challenges for individuals in need of guardian while they're on the waiting list for appointment of a long-term public guardian. So as previously stated, a legal guardian is necessary to access a payer source like Medicaid and to consent to treatment decisions like transfer to a post-acute facility. So this creates a problem where a patient may wait for several months on the waiting list for a public guardian, and then once the public guardian is appointed, once they've waited for the appointment, only then can the guardian begin the process of enrollment for public or private benefits for the patients, which that adds days, weeks, or months to the process. By engaging a temporary guardian while the patient is on the waiting list for the OPG, for the limited and specific purpose of applying for private or government benefits, we envision that this would provide a quicker transition to placement once a patient is finally off the wait list and has a long-term guardian. I understand that the OPG will be asking to do this work under their existing caseload cap, as this would create additional workload. Per the 2022 annual report, the average ward in full guardianship requires 4 hours per week of service from an OPG, including monthly in-person visits, communication with direct service providers, financial case management, and response to emergency needs. Under this limited temporary guardianship, the responsibilities will be a limited subset of financial case management, gathering financial and personal information, completing application documents, and will likely be significantly less stressful and time consuming than some aspects of a full guardianship. So we're just trying to find a solution here. I'm committed to addressing the needs for increased OPG capacity, including increased funding, but we're also trying to find creative strategies to enhance capacity within the existing arrangement. After our hearings yesterday, for some reason that triggered something maybe I was thinking about today. And I had this new idea to use an appointment mechanism similar to what we do in defense attorney cases in places where there is not a public defender. The court can appoint someone from a list of attorneys who have volunteered to do this work, to be a public or a defender in a county where there is no public defender. I imagine a similar process. It would be similar to our guardian ad litem process, where the court goes through a list of people in the county who are willing to act as public guardians, these be attorneys, and we do this for the temporary position for applying for Medicaid. Obviously, this is a work in progress, and I don't have an amendment to show you. But the idea would be to do exactly the scheme that I have, but try and do that. The state pays for this, but it would be for folks who are willing to do it on an appointment basis. Maybe they don't want to be a full-time OPG. And this would allow us to get folks throughout the state and in Omaha and Lincoln, where I understand the needs are the highest, to do these guardianship positions on a temporary basis. At least that would get folks further along the process and speed them up a little bit. So I'd like to make sure we discuss this in this hearing. I've tried to talk to folks and kind of let them know that this is an idea I've been thinking about today. Some folks have suggested, well, shouldn't hospitals pay for guardians? There's a couple of, I want to introduce that question as well, because that was one mechanism folks were talking about. But here's the problem. You don't want someone to pay for guardians for folks that they're trying to get out of their hospital. Conflict of interest there, right? If it's not the right thing to get someone out of the hospital, you don't want a guardian to feel pressure from their employer or the person who's giving them money to be a guardian to say, oh, let's get them out of the hospital. So you can't have a direct pay from the person who's doing the care. It has to be some other thing. Someone said, why don't we just have hospitals pool money and then from there they get hired? So it wouldn't be that direct benefit. But why should the hospitals be paying for this work that, as I said in my close for the last hearing, really should be something that is done by the state? The state has created a mechanism wherein folks need to have some kind of legal guardian, and we should fund that legal guardianship. So I would suggest a pilot program either in a county with the city of the primary class or a county with the city of the metropolitan class, which is Lincoln or Omaha, where we could try to do something with a temporary guardianship that would be appointed by the court, similar to our guardian ad litem structure. I'm happy to answer any questions.
Senator DeKay.
Real quick, you triggered something when you said about having when the question was asked about having hospitals funded. The concern that I have with that is a lot of your rural hospitals are basic critical need hospitals. They're working on a shoestring budget right now, and to be able to come up with more revenue to cover those costs would be very detrimental, especially to rurals where they're basically just prepping them. End of decision might need to be made by a guardian, but they're just prepping them to move on to a bigger hospital. So that's a concern we have with that.
I absolutely agree. I don't think this should be on the hospitals. It should be on us. We should be paying for this because we are the ones who create the legal structure that they're caught up in.
Any other questions? I have a lot, but because I'm in this area, I'm appointed as a court visitor, GAL, on many of these cases, but in the essence of time, we can have those conversations in exec or wherever, but I'm real familiar with the problem. In fact, I'm sometimes appointed, just so people know, if anybody says I have a conflict or whatever, I'm appointed sometimes in Douglas County to be a guardian ad litem, not a court visitor, but to also help go out and find successor guardians, because the waiting list is so long that the court is appointing people in Douglas County to see if they could figure out if there's somebody out there that could do it. So just so everybody knows that I don't have a lot of those cases. I think I only have 2 or 3 pending right now, but what happens to this bill doesn't change what I do, but I want people to understand that if there's an appearance of something, that's what it is. I have no questions, so we'll start with proponents. Yeah, I have a very wide range of practice, Senator DeKay. I came down here and lost all my criminal clients because they like you to show up in court. They get arrested not on your own time, so it's kind of hard to plan. Welcome.
Good evening, I think officially. Now, my name is Tiffany Yackel, Tiffanyjoekel, and I'm Director of Government Affairs at Nebraska Medicine. It's late and I won't belabor the point I think has been clearly made. Our hospitals and others in the state are struggling. We have situations in which we come to a last resort, which is a need for a public guardian. We have exhausted friends, family, and people are either unwilling, unavailable to serve in this capacity for patients. We don't take this lightly, not only because it is a very serious legal issue to pursue guardianship, but also it's not a prompt response. It's not something, so we pursue this absolutely as a last resort. LB 157 is an attempt to provide some way to address the challenge that we face. So at this point, a patient may wait on the wait list, and after they get a guardian, it's only then that we can really begin to pursue any public benefit process, because it's not necessarily because our health system can't help with the application for Medicaid, for example. We can certainly do that. But what we can't do, and I don't think it's appropriate for us to do, is get access to bank records, retirement, pensions, any sorts of asset or financial information that may be important to determine what sorts of public benefits a patient may be eligible for. So that means that we have to wait on the wait list, and in some cases that's months, and wait until that we finally get a public guardian appointed, and at that point the public benefit application process can really start in earnest. This does not solve the problem, but it is one effort to try to think creatively about how to help this process along so that a patient can move to the more appropriate level of care as quickly as possible. I want to just speak to some challenges or some issues that have been brought about this temporary limited purpose won't remain temporary or limited as is written in the bill. I do understand that there are some temporary guardianships that are extended currently. Temporary guardianship exists currently, and there's a concern that this will just do the same thing. The way the bill is written right now, it's very limited to application for public or private benefits. So while it may continue, it's only for that limited purpose. So it's not as if this limited opportunity can make placement decisions or make medical decisions. This is a very limited purpose to meet a very limited need. I also want to acknowledge the hard work that OPG does. They do deal with some very difficult cases, but sometimes something like this would help us tremendously. We had a patient that was with us for 300 days. We had a placement willing to take them, but placements don't take them without a payer and they don't take them without a guardian. So we waited those 300 days until a guardian could get in place before we could start that conversation. So with that.
Any questions from the committee? Senator Holcroft.
Yes, Chairman.
I was just thinking, I
Wayne.
know his name. I just couldn't grab it. Oh,
Late on a
Thank you,
Friday.
Chairman Wayne. So help me understand, so they're in the hospital for 300 days. Obviously, they're accruing fees, expenses, which you're not collecting or trying to collect?
So the way hospital inpatient care is financed, it's typically, we are paid an amount based on the diagnosis that patient walks in with. And so that diagnosis, let's say it's on average, they anticipate a 6-day stay, and there's a certain average or estimate for the kinds of procedures that will be required. So we're paid a lump sum based on the diagnosis that patient walks in with. If they stay for 6 days or 60, we get paid that same amount. So there is no additional compensation per diem for the days that they stay.
Paid by whom?
Us. We absorb that care.
Okay,
I mean,
so-
we're, for that initial reason that they come into our hospital, if they have a commercial payer, they'll pay that DRG. If they're Medicaid, whomever their payer is that comes in pays that initial inpatient. But for any extended stay that's beyond what they came in for acute patient care, our hospital absorbs the cost of that.
So once you get a guardian and they do the paperwork and say they qualify for Medicare or Medicaid, you try to go back and collect your back fees on the,
We
just
can't,
absorb
there's no per diem structure set up in Medicaid. They pay us for the diagnosis that they came in for, and that's how it's set up. So there is no recoupment for, the 30 days that they stayed beyond the average or what was.
But don't they qualify, depending on the age, of course, for Medicare while they're in the hospital?
Yes, same. They also pay on a DRG basis. So it's based on that diagnosis-related group is the DRG. It's a lump sum amount. So again, they pay based on the diagnosis, not how many days they stay in our hospital.
Okay, thank you.
You're welcome.
Any other questions? See you none. Thank you for being here.
Thank you.
Next proponent. Welcome back.
Thank you. Chairman Wayne and members of the Judiciary Committee, my name is Margaret Weppel, M-A-R-G-A-R-E-T, W-O-E-P-P-E-L. I'm the Vice President of Workforce Quality and Data for the Nebraska Hospital Association, and I am testifying in support of LB 157. You have the data in front of you. We've talked about it at length. But I would just like to focus in on the temporary guardian as a add-on to LB 761, which was brought by Senator DeBoer, $700,000 in the Appropriations Committee. The appointment of a temporary guardian for the limited purposes of assisting a person in applying for private or government benefits will help. In the hospital setting, the patient waits months for a public guardian, and only after they have a public guardian can the patient begin application for Medicaid. The Medicaid application can take weeks or months on top of that wait for paperwork to be found, gathered, and approved. All this time, the patient is waiting for transfer to the appropriate level of care. An interim temporary guardian who can simply help patients start their benefits application can shave weeks or months off a patient's unnecessary wait. Any questions?
Any questions from the committee? I like that testimony.
Thank you.
We got a minute 50 left. All right. Next proponent. Wait, we're talking proponents.
You are correct, Senator. This is the first time my agency has sent me in behalf of a bill.
We are having fun on a Friday. Welcome.
Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Bo Botelho, B-O-B-O-T-E-L-H-O, and I am the General Counsel for the Department of Health and Human Services. I'm here today to testify in support of LB 157. Some Nebraska residents who need public assistance lack the capacity to apply for it. While guardianship proceedings can be initiated to appoint a guardian for incapacitated persons needing assistance, it can be difficult to find someone willing and able to serve as a guardian. Persons who are not interested in serving as a temporary or permanent guardian for all purposes might be willing to serve for the limited purpose of applying for benefits. Exempting these temporarily limited guardians from the caseload ratio of the Office of Public Guardian would potentially increase the availability of members of that office to perform this important function. Although a temporary guardianship may not resolve all needs, it will allow the department to establish needed services and help stabilize the individual's circumstances. Receiving public assistance can help people live their best lives by allowing them to receive the appropriate level of care in the most appropriate setting. DHHS respectfully requests the committee to advance LB 157. Thank you for the opportunity to testify. I'll be happy to answer any questions.
Any questions from the committee? Thank you for being here.
Thank you, Senator.
No, he's a proponent. Okay, make sure we get that right. Welcome.
Good afternoon again, Chairman Wayne and members of the Judiciary Committee. My name is Dr. Lisa Vail, L-I-S-A-V-A-I-L, and I am Assistant Vice President for Patient Care Services and Chief Nursing Officer at Brandt Health. From the conversation this afternoon, I am speaking on support of 157. However, we might be able to expedite the ability to get a temporary guardian to move forward with financial paperwork and getting that process going. It would save significant time for us, because again, we cannot do that and find a place concurrently. We need guardian first before we can find the payer source. And it does make a huge difference, not only for these patients, but for everybody else who needs services at our hospitals. Just this week, due to the complexities of some of these patients and others, we're at full capacity and holding 25 plus patients in our emergency room with no beds to put them in. And it's been that way for the last 3 days. So it's making an impact in our ability to care for those who truly need acute care services. So I just want to thank Senator DeBoer for her continued focus on the post-acute placement challenges in our state and for all of the conversation this afternoon. And I really hope that we can find a solution to seek this support for the principles of 157. Thank you.
Any questions from the committee? Seeing none, thank you for being here. Next proponent. Next proponent. Okay, moving to opponent. Next opponent. Welcome.
Again, Chairman Wayne and members of the Judiciary Committee, my name is Michelle Chafee, Michellchaffee, and I serve as the Director of the Office of Public Guardian. And we are opposed to 157 as it is written to include the Office of Public Guardian taking on temporary guardianships without counting towards the Associate Public Guardian's caseload. Because of the late time, I'm just going to jump to a few things. One is, if you would look on the second page, which is a breakdown of what Medicaid applications and what it takes for, even if it's a temporary. The Office of Public Guardian had looked through our cases, and we had 32 cases that we were a temporary guardian for that needed benefits. And as you will see, that the temporary guardianships, it's not the application process, it's the verification of the funding that becomes an issue. From our representative samples, the average case took 138 days to get Medicaid. The minimum was 6 days and the maximum was 388 days. So when you're talking about here, just take this and just add it to your already caseload and just do it as a temporary because it's like 90 days. That's not the way it is. The total hours spent on all cases in the representative sample was 2,712, an average of 77 hours for being able to get to the place where we could have Medicaid. The range was from 13 hours minimum when it was really easy. There was no assets, you just file it, and 413 was the maximum. If you look at the last two handouts that I gave you, those are the toolkits for Medicaid, and it'll show you what you have to go through in order to provide and get Medicaid. So when we start talking about a temporary guardianship that's going to be added to the Office of Public Guardian's responsibilities, please be aware, we're not talking about filling out an application. We're talking about finding assets, figuring out the real estate. And then the other thing you need to realize is that 63% of these cases don't get okayed until they go through an appeal process. So you have to appeal the process. You have to, or you have to spend down their assets. And so it's not about temporary just to apply for Medicaid. You have to do the verification and all of the work to do it, especially if you have to sell property in order to get the Medicaid. So I'm not against, if that's that wants to be done, I think you could do that for temporaries, but not the Office of Public Guardian as seeing like that's just a temporary, and we should jump ahead of all the waitlist cases in order to take the temporary Medicaid applications.
Thank you for your
thank
testimony. Any questions from the committee? Senator Hogarth.
Thank you, Chairman Wayne. I'm just curious, well, somewhat curious. Not recently, actually been a few years that took care of my mother transition, And she had assets, I mean, we went to an elder care lawyer and to preserve assets, that she gave us an option to where we could move money into trusts. We could, make her appear poor. It was all legal. But we qualified her for Medicaid if we wanted to. Now, we never executed the plan, but do you go through all those steps with these folks, or do you just pretty much spend down their savings and then until they qualify for Medicaid?
It really depends on, it depends. Most of the time, though, that when we get them, I'm talking about assets of a house or assets of, $2,000 or $3,000, $4,000. We've had 3 cases where we've had millionaires who are under our care. One was a rancher, a lady who never had family. She had a trustee, so we just did the medical decision-making, so we didn't do any of the elder plans.
Okay,
So,
thank you.
yeah.
Any other questions? So attorneys can be appointed. I think you were here when I said that I get appointed sometimes to find successor guardians. How would you feel if the court started appointing attorneys as temporary guardians for that limited purpose?
They already do that.
They already do that.
In fact, with legal aid, you're aware that they have the contract for a lot of the hospitals to find petitioners, to petition for guardianships.
But those are the ones in the hospital. So I'm just saying, so like I file a petition for an emergency, invoke the public, you send back the caseload's already met or whatever, can't find anybody. What if we gave the authority to judges to, at that point, appoint attorneys as temporary guardians? No, I'm not asking for more work because I'm down here too much, but.
No, we do that, and it's done often, and it's done consistently. There's temporary guardians who are attorneys.
So how do your standards in that, when we go through the training, but I'm trying to think of your reporting and what you do, how do we ensure the court matches kind of what you're doing so it's a smooth transition to when the office picks up?
Well, you'd have to go you'd have to file you'd have to file a temporary first. And so once the temporary, you could do a temporary and permanent, and that gets filed. And then you come in and say the temporary, and this is how it's done. They do a temporary and they identify a guardian ad litem, an attorney. And so when they get off of our wait list, when we say, hey, we have, then the temporary automatically gets put onto us as a permanent.
What I'm saying is right now, there's, I don't know if I call it a movement, I don't know what to say, that attorneys right now in Douglas County aren't even recommended for an emergency through Office of Public Guardian, because we know you don't have a wait list. So you're not even getting requested. And so I think.
Okay, I see what you're saying.
So I'm saying that there's a mechanism, maybe through your office, where we say, so
if you take a temporary.
So in criminal cases in Douglas County, attorneys go through training, they're on a list. In order to be a juvenile guardian, you have to complete, and you're on a list, and courts can appoint from that list. I don't think we have the same thing for temporary guardians, but what if that was created and your office maintained that list, but it gives judges the opportunity to be temporaries? I mean, not judges, but attorneys. So there's a list. Would that be something you'd be interested? I mean, of course it costs money, but would that be something that maybe you would help with in that process, or could?
Right. Absolutely. We're open to a lot of things. Let me just share for example, one of the things that we're doing now is seeking out volunteers who would be guardians, period, and then processing that and providing that information to the court so that they have, and we're working in conjunction with Adult Protective Services because they have difficulties. So we'll be looking at volunteers. We also, if there's a temporary that's being done currently while they're waiting for us on the wait list, then they usually file for us to be permanent while they do the temporary. And when they're identified, then they.
So how many, and this is the last question, how many, have you seen a migration where Douglas and Lancaster County are moving people out of their out of the jurisdiction, however you break it up, the east to other ones, just so they can get appointed office?
Well, yes, but the rules are that you have to file it where the person resides. And so if they're at Douglas County, they have to have the guardianship filed in Douglas County.
But if the guardianship's filed, but if we find a placement that a place takes somebody in Ponca, we'll move them up there and then transfer it over there, and then magically the list is no longer full, so they can be on the list. Have you seen that movement from like people doing that?
I've seen people try to work that out, and actually we have 2 openings in Scotts Bluff, so anybody who wants to transfer over to Scotts Bluff, but they're not doing it out of the hospital, so.
I was just seeing if I was the only one doing it. That's
Yeah.
really what I was trying to.
One thing that I'd like to just say though about what was testified to in regards to temporaries and why people are in hospitals so long waiting for payer sources is because that's a requirement, and they get these bills because they're not paying for what the hospitalization is. That's because long-term care refuses to take them until the payer source is there. Even though if they would take them, Medicaid pays 3 months in retrospect. So if you get them into the nursing home, then they still have 3 months that they can collect.
No, I understand that. The issue is the temporary getting them there. And so the other issue is those who aren't in medical. I mean, literally, I'm going through this right now. I mean, we're petitioning, and I know you guys are full, but anyway, well, yeah. Anyway, thank you.
Yeah, thank you.
If it wasn't Friday, we would keep talking, but it's Friday. Next opponent.
Good evening, Chairman Wayne, members of the Judiciary Committee. My name is Tim Haruza, last name spelled H-R-U-Z-A, appearing today in opposition to LB 157. On behalf of the Nebraska State Bar Association, I want to be clear that the bill has 2 component parts. The first part that authorizes the appointment of a temporary guardian for purposes of obtaining benefits or applying for benefits, I don't think we really have an objection to. There are a lot of questions, and I think it was alluded to by one of the testifiers earlier that there are questions about the temporary nature of that and whether it will affect it. But as Mr. Vitello also testified, if you can get an attorney or a family member or a kinship guardian that would be willing to accept an appointment, and a lot of these cases are long-term and difficult, but if you can get somebody who might be willing to accept a limited appointment for this purpose, it should be an option. And I think that might open up a lot of avenues. We're fine with Section 1. The concern is the impact it has on the Office of Public Guardian to take those cases out from under that case ratio that we discussed in the last bill. Clearly a need for this without question, but those cases are the ones that the public guardian is taking and getting right now are very intense, time intensive, and difficult cases. The concern is the strain that this would put on them and the ability, if it's not within that case ratio, the effect it would have on the ability to serve those that are more permanent guardianship appointments or more long-term guardianship appointments if these are jumping up in line. With the last minute I think I will just say that we've had good discussions with Senator DeBoer. To some of your questions, Senator Wayne, I think we are open to a discussion about a situation in which an attorney or temporary attorneys, private attorneys might be appointed with some funding that would be available. I do know that happens in some counties right now, paid for at the county expense. I think there are some county court judges that have told me that happens where they appoint attorneys for these types of cases. But we are open to exploring and communicating and getting more resources to ensure that these issues are addressed. With that, I'll answer any questions and thank you for your time.
Thank you. Any questions from the committee? I can't do the clock and ask questions, so we're good. All right, thank you.
Thank you.
Next opponent. Welcome.
Good afternoon, good evening, Senator Wayne and members of the committee. For the record, my name is Brad, B-R-A-D, Meurrens, M-E-U-R-R-E-N-S, and I am the Public Policy Director with Disability Rights Nebraska. We are the designated protection and advocacy organization for persons with disabilities in Nebraska, and I'm here today in opposition to LB 157 as currently written. I'll have a brief statement given the time of the hour. We are not dismissive of the situation giving rise to this bill. However, as the protection and advocacy organization, we have a particular interest relative to guardianships and persons with disabilities. As one of the organizations that supported the creation of the Office of Public Guardian, we are also concerned with its efficacy. We would encourage the legislature to work to explore alternative options. We share and echo the concerns of both the Office of Public Guardian and the other opponents today. And with that, I would also say that Disability Rights Nebraska stands ready and willing to assist in any way we can in addressing solutions to this particular issue. I'd be happy to answer any questions.
Any questions from the committee? Seeing none, thank you for being here. Thank you. Appreciate the work you do. Next opponent. Anybody testifying in neutral capacity? As Senator DeBoer comes to close, we have 2 letters, one in support and one in opposition. Welcome, Senator DeBoer.
Thank you, Senator Wayne. Well, we have a big problem. We got to find a solution for it. I think it's going to take a multitude of different approaches. I think we should investigate doing something more with appointments. That doesn't mean that everybody in Douglas County and Lancaster County with the bar license is going to jump up and try and take as many of these cases as we could possibly give them. But maybe it's an option to try and do something with that for these temporary guardianships. As you heard, I have asked for money to help with staffing over in the Office of Public Guardian. I think we need to take a number of different approaches. And yeah, I'm happy to answer any questions.
Any questions from the committee? Seeing none, thank you for being here. Now to close the hearing on LB 157 and today's hearings. We outlasted revenue. They just finished 20 minutes.